Testing.
Okay, and there it goes.
Okay. Is the recording and the recordings all live? Loretta, is the streaming on?
Yes.
It's all on, all set to go then? Okay, I'd like to call this meeting of the Holmdel Township Zoning Board of Adjustment to order. It's a special meeting, today being Wednesday, June 29th, 7 o'clock. We're now 7:04. Francine, call to order, please.
In accordance with the Open Public Meetings Act, NJSA 10-4-10, and the regulations governing remote meetings, NJAC 539(1.5, I hereby announce that adequate notice of this meeting was provided in a notice dated January 19, 2022, and June 23, 2022, that was sent to the Asbury Park Press, 2 River Times, posted on the bulletin board and on the main access door to Town Hall, filed in the clerk's office, and posted on the township's website, www.holmdeltownship.com.
Roll call, please.
Ms. Avron?
Here.
Mr. Luciani?
Here.
Ms. Campus?
Here.
Dr. Lateef? Mr. Burkle? Mr. O'Banatopoulos?
Here.
Dr. Blumenthal?
Here.
Ms. Perez?
Here.
And Dr. Shaw?
Here.
I'd like to seat Ms. Perez and Dr. Shaw for the two people who are absent tonight for all matters on tonight's agenda. Please rise for the Pledge of Allegiance and then stay standing for a moment of silence to honor the police and military who've been wounded or killed in action. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Item number 1.
Continued public hearing, 470 Red Hill Road, Dementia Center, preliminary final site plan, number 2020-6, lot 49-02, lots 40, 42, and 41 in the R40B zone. Applicant seeks a use variance to create an assisted living residence, which will be a facility for those suffering from dementia for 105 residents. The facility will consist of a state-of-the-art residential memory support program that will house a variety of innovative programs and building design concepts, including an assessment program, educational services, and extensive community outreach and support.
This is a continued public hearing on this application. We're following state-mandated procedures and the rules of this body. Depending on how the testimony continues, our typical process is the applicant has a witness, and after the completion of that testimony, there, at the discretion of the board, may be an opportunity for members of the public to ask questions about that testimony. Only at the conclusion of all the applicant's testimony, and then there are a couple of objectors' testimony, will there be time for public comment. And we may or may not reach that tonight. Mr. Brown.
Thank you, Mr. Chairman, members of the board. Thanks for having us tonight. Thank you for your continued service. We're going to start with very short testimony from the gentleman to my left. He's an expert in dementia, and we will slip right back into Mr. Higgins for the completion of his testimony. I'd like to...
Is your mic on? Do you see a little red light? If not, flip the switch underneath.
How's that?
Good, that's
Oh,
better.
thank you. So I'd like to call Ken Zaintz to be sworn in, please.
All right.
You're going to stand.
You swear to tell the whole truth, nothing but the truth, so help you God.
I do.
If you just state and spell your name for the record, please.
It's Ken, K-E-N, last name Zaintz, Z like zebra, A like apple, E like Edward, N like Nancy, T like Tom, Z like zebra. I'm very used to doing that. So.
So Mr. Zaintz knows Holmdel very well, so I feel comfortable calling him Ken. And Ken, what's your present position?
I'm the president and CEO of Alzheimer's New Jersey.
And are you familiar with Holmdel?
Yeah, I'm actually a Hornet graduate. I lived in Holmdel since moved to Holmdel in 7th grade, graduated Holmdel High School, and unfortunately just sold my parents' house about 4 or 5 years ago because they're both now gone. So I know Holmdel very well, and I am, for that reason, in addition to my, my professional role, I'm pleased to have this opportunity to address the public and the board.
And so you're very familiar with what's historically been called Potter Farm, is that correct?
I am. My dad used to get his lawn equipment sharpened there, so.
Yeah. And you're familiar with the proposed project, are you not?
I am.
Would you let the board and members of the public know a little bit more about what you are in charge of?
Sure. So, as you all probably know, Alzheimer's disease is life-changing, not only for those who have the disease, but for their families as well. Nicholas Sparks.
If I could just
Yep.
stop you there. I think before he continues, I'd like to have Ken Zaintz become authorized as an expert in dementia.
Is there any questions? You want to say a little bit more about your background?
Right.
Sure. So tomorrow will be 25 years that I've been working for Alzheimer's New Jersey. I have been, I've been involved on every level. When I first started out when I was first hired, we were a tiny little organization. I was the first full-time staff member. I had to do everything from, counseling caregivers to running fundraising events. I've been to, numerous conferences, local, national, run them. I've testified in front of, in Trenton for legislation that benefits people with Alzheimer's disease. So, I've been doing this for a really long time. I've worked with a lot of families, who have the disease, and I'm not a doctor, much to my mother's disappointment, but I do know a whole lot about this disease and can speak to it on many levels. So.
How many folks work for Alzheimer's New Jersey under you right now?
So right now we're about 15 in total, full-time, part-time. We're in that sort of, hopefully we're in the post-COVID, bulk back up and higher. So, we're growing. We're a community-based organization. At one point, we were part of the National Alzheimer's Association, but our board of directors, in response to some decisions that were made by the national organization in terms of restructuring, decided to that we really wanted to be able to concentrate 100% of our resources on people in New Jersey. So we left the national organization in 2015, changed our name to Alzheimer's New Jersey. Our legal status remained the same. And we've been working exclusively 100% to benefit New Jersey families who were impacted by Alzheimer's disease for the past 6.5 years. Actually, we always did that, but now we're doing it as a much more local, community-based organization.
And you have 3 offices throughout the state, is that fair to say?
Correct. Bergen, Middlesex, and then our main office in Essex.
Any other questions about his qualifications?
Yep, I do.
I do.
Oh, go ahead, you first. Go ahead.
So I certainly respect you have a lot of experience, but experience being qualified by an expert are not the same thing. I haven't heard any expert qualifications, Mr. Brown, that would deem me to, I would think would qualify him as an expert. So if you want him to testify with his experience, then obviously we're all going to listen based on his extensive experience, but I would not vote to, at this point, I'm sorry, to have him admitted as an expert.
Could you provide a little more background?
I have a comment too. I would like to know the scope of what he's testifying. If he's testifying about the disease, that's fine, but he shouldn't be testifying about the site and its location or anything that has to do with that.
Well, he will talk generally about the trends in the particular industry in question, And so to that degree, he will talk about the project.
I don't accept him myself as a witness an expert in witness in that area.
All right, could you provide a little more background in terms of your training, your education, and how you have become to know the field of Alzheimer's, which led you to run this statewide organization?
Sure. So, I mean, my undergraduate degree is in government and political science. My graduate degree is in education. I started my career as a teacher. I have worked for hospital systems. When I made the transition, I worked for another national nonprofit organization. I've worked for a hospital system. I've worked for a community college, all in volunteer management and fundraising. I came to work in the Alzheimer's field in 1997. I've been there ever since. I have, I've been involved in lots of issues, federal and state, for people to advocate for families who are impacted by Alzheimer's disease. I've read everything. I've run statewide conferences with national experts in the field, physicians, social workers. I've worked with numerous families, so it's really 25 years of experience in this field, working at every level that, I've had lots of conferences, lots of conversations with lots of physicians, held my own, with physicians at Princeton University in discussions on this topic. So if you're looking for formal training, like I said, I'm not a medical professional, but, I've been immersed in this field for 25 years.
And have you been involved generally with DOH regulations in terms of how it relates to treatment of dementia and Alzheimer's?
Yes, as a matter of fact, under former Governor Christie, I was on a commission that put together a statewide Alzheimer's disease plan for the state. I was one of the appointees on that commission and served on that, with a number of other experts in New Jersey, putting a statewide Alzheimer's disease plan together.
About how many folks or families have you dealt with over your term with Alzheimer's New Jersey or its predecessor who have had Alzheimer's?
Probably hundreds, thousands. I mean, right, our helpline alone, we get about over 2,000 calls a year from families, from people with the disease. I've been involved in support groups, with families. So just about every aspect of the disease, I have been involved with.
Mr. Chairman,
Yep.
there are certainly many kinds of experts in different fields. He's not a medical expert, of course. I would submit that experts can be qualified for different reasons, and members of the board can take the qualifications to the extent they would like. In the very least, he should be able to testify about his knowledge, but I would still offer him, as I indicated before.
I respect his experience, and I have no objection to him testifying as to his knowledge. I would not vote to qualify him as an expert. First of all, I truthfully don't understand what we'd be qualifying him for. He's not a medical professional until he testifies. I don't even know what the scope of his testimony is going to relate to. So
I would agree. We'll let him testify from his experience, and we'll go forward from that.
That's certainly fine. Very good. So, Ken, we promised ourselves that you would be short, so let's get right to it. Go ahead.
Sure. So I really want to focus on, what I really want to focus on is the need. As I started to say earlier, I'm sure everyone is familiar with Alzheimer's disease. It is a devastating disease. It takes a huge toll on not only the person with the disease, but on their family members. As it gradually disconnects families in terms of shared memories, the person with the disease eventually loses all of their cognitive abilities, their ability to perform tasks of daily living, and unfortunately, barring COVID, it is now the 7th leading cause of death in New Jersey. It was 6, but now it's 7 because of COVID. We know that Alzheimer's disease is not part of the normal aging process, but age is the greatest risk factor for developing Alzheimer's. 1 in 10 people over the age of 65 are affected. That makes New Jersey one of the highest states in the country in terms of the number of people with Alzheimer's. New Jersey has an over 65 population of 17%. Monmouth County's, however, is higher at 18%, and according to the 2020 census, Holmdel's is even higher. 20% of the population of Holmdel is over 65. So if you apply the 1 in 9, or the 1 in 10 rather, people affected by the disease over the age of 65, there are a lot of people in Holmdel that are impacted by this disease who have it, and then of course there are caregivers. We estimate that it takes more than one person to provide care for someone with Alzheimer's. So if you do the math, it's an estimation, but there are about 600,000 people in our state that are impacted by this disease. So with approximately 190,000 New Jersey residents with Alzheimer's disease today, 10,000 baby boomers nationally turning 65 daily, no cure for the disease, no way to slow it down on the immediate horizon, the number of families impacted and the need for community and residential services will continue to rise exponentially. It's an epidemic. Most of the care for people with Alzheimer's disease is out of pocket by family members. Private insurance doesn't cover most of the needs. Families try to care for their loved ones at home for as long as they possibly can. But for many families, for many different reasons, that becomes impossible. So what do families do? They look for a community setting for their spouses and partners, for their parents and grandparents that is close to home and provides their loved ones with community-oriented therapeutic approach to care that emphasizes dignity, independence, and respect for the abilities that the person with Alzheimer's disease still has, which is very different than an institutional setting where the emphasis is really on disability, not about ability. So based on my knowledge of this particular project and based on what I know from thousands of conversations with families, this is what they want. This facility, in my opinion, is what families want and what those with dementia need, because it meets the criteria of ability to live in a community. For many of these families, live in the same community that they live in right now, Holmdel Township. To live there with dignity, to live there with respect, and to have an emphasis on what they can still do as people with Alzheimer's disease, who we can still have an emotional, loving relationship with, even though the connections to the present are gone.
I have no further testimony from Mr. Zink, so he can answer any questions anybody might have.
Board members have any questions on the testimony we've just heard? Kate or Bob? Nothing? Now, I believe you have to leave, or?
Yes, well, I like to have him to be free to leave.
Okay, that's what I wanted to clarify.
The public has to ask
Yeah, in
questions.
case, if none of the board members or professionals have any questions. Do any members of the public have any questions about the testimony from Mr. Zink that we've just heard?
Hello? I think it's on. Kevin Asadi, Zager Fuchs. Mr. Zanes, do you know how many memory care facilities are licensed in New Jersey?
Not off the top of my head, I don't.
Do you know how many are licensed in Monmouth and/or Middlesex counties?
I don't know those numbers.
Do you know how many beds are currently available for memory care in Monmouth or Middlesex County?
Do not.
Have you ever operated a memory or dementia care facility yourself?
No.
You talked about in your experience with the Alzheimer's organization.
Correct.
Forgive me, I missed the exact
Alzheimer's,
name.
New Jersey.
Alzheimer's, New Jersey. Forgive me. You talked about a helpline. What was the nature of that helpline?
So one of the services that we provide as an organization is a helpline that's available to families. Families call about all kinds of questions, and it could be just trying to basically understand the disease, questions about, I suspect that my partner may have Alzheimer's, what do I do about it, to families who call because they made the promise that they would never place their partner, their grandparent, in a residential setting, but they just can't do it anymore. And so what options do they have? What's out there? What do they do? How do they make the decision? What do they look for? And the things that families tell us they want are some of the things that, that I testified to in terms of, what they're looking for in placement. So many families want to be as close to their loved one as possible. So that's why I was saying that, you may find that many of the people who end up to be residents in this facilities are already living in town. It's your parents, it's your grandparents.
Along those lines, are there any zones in Holmdel where this kind of facility would be a permitted use?
I'm going to object. He's not here as a zoning expert.
He was offered as a pretty broad expert.
He can answer if he knows.
Sure.
If he doesn't, he doesn't know.
Yeah, I mean, I know that there are other facilities in Holmdel. I have no idea what the zoning is. That's not my area.
Okay. This location, though, are you familiar with its location in relation to the Garden State Parkway?
I am.
Do you think that its location along the parkway makes this a convenient location for people from outside of Holmdel, like northern New Jersey, Connecticut, Long Island, Staten Island?
I mean, it's off the parkway, so that alone makes it convenient for just about anyone who wants to travel. All I was saying is that what we found is that most families, because they want to visit, and families and facilities are more than just visitors. They're part of the care team, so they want to be as close as possible. So, just anecdotally from, what we talk to families about and what families tell us, people aren't coming that far to place their loved one in a residential community.
Are you familiar with how many memory care or dementia care beds are available right in Holmdel currently?
No.
Okay. I don't have any further questions. Thank you.
Are there any other members of the public who have questions on this testimony? Please come to the microphone and identify yourself for the record.
Thank you. I'm Jane Zisk. My address is 6 Lucarelli Drive. If I heard you correctly, you said that it takes more than one person to care for an Alzheimer's patient. So what is the ratio of caregivers to patients in the proposed facility?
That's been testified to before. I don't know if Mr. Zanes knows that detail. You can distinguish.
Yeah, no, I don't. I don't know that level of detail with this application.
Well,
Okay.
let me expand your question for a moment, if I may. There's different person-to-patient ratios in different contexts. There's the one context if someone's at home and there are other family caregivers.
Right.
One in a commercial or semi-commercial operation of how many employees are to. So would you clarify what you were referring to?
That's a good question. I was talking about the impact on family, and normally, one family member cannot do it all, and so that's why families eventually, unfortunately, get burned out, and they can't do it any longer at home. And when you look at the numbers and you look at the projected increase in the number of people impacted by Alzheimer's, it's huge. And so families need alternatives. Families need continuity and continuum of care. Not everyone belongs in assisted living, not everyone belongs in a nursing home, but there's, this is a progressive disease and needs change, as the disease progresses. So, families want, families want choice. They want facilities that meet the needs of their loved ones. So, that's what I was referring to.
Thank you.
My name is Aaron Held, and I'm a Holmdel resident at 6 Robin Road. Mr. Zanes, hearing your testimony reminded me of my grandfather's long journey with Alzheimer's, and also some of the financial burden that was placed on my family in his long-term care. In your experience as CEO, I believe you said, of Alzheimer's New Jersey, are these facilities for-profit facilities, or are they non-profit facilities? What is in general your experience on the level of, shall we say, the business aspect of these facilities?
So, to answer your immediate question, there's both. I mean, there are some facilities that are for-profit, and there are some that are not-for-profit. This facility is not-for-profit. I'm not going to, there are definitely differences. Obviously, in any for-profit facility, there are shareholders that need to be satisfied. You don't have that in a not-for-profit. So, does that necessarily translate into better care? I can't comment on that. But, in our experience, the nonprofit facilities certainly have, since there are no shareholders that are looking for a return on their investment, I mean, there is a big emphasis on, on care. Not to say there aren't in for-profit facilities, but it's just a different way of, kind of looking at things, so.
And then along those lines, do you find most of the nonprofit organizations that are building facilities, are they what you would consider larger healthcare organizations or smaller healthcare organizations?
Yeah, I think it varies. I mean, the assisted living it used to be Bayshore, now it's part of the Meridian system, but that assisted living was built by the hospital, and they're a not-for-profit. They're certainly a much bigger non-for-profit corporation than we are. So, there's a variety of sizes of not-for-profits, and, a variety of sizes of the not-for-profit corporations that run facilities. Some of them may only be, single facilities. Some, may run more.
Now, just because it's a not-for-profit status, in your experience, the UMC that's proposing to build this facility, what do they offer? You'd say, what would they offer someone who lives in town as what would they charge for that level of care?
Yeah, I don't know. I couldn't answer that.
That's been testified to before.
Would there be discounts? Would there be incentives for people that are in town, in Monmouth County,
Well, I can
to
answer
make
that.
use of this facility?
By law, there can't be discounts for people in town. There's already been testimony that UMC is putting in $10 million into the initial construction and the beginning phases of this. So I think that, I don't know if you even were aware of that.
Yeah.
So there's a lot of money involved coming in.
There's a lot of money that has to be put in by this not-for-profit organization to have this come to fruition, to provide basically a public service for a new kind of step in dementia care.
Has it been testified what the compensation of the UMC board is to this?
No,
I can.
It's not
zoning
relevant
board?
to this witness.
Yeah.
your question's not relevant to this.
I can
witness.
tell you,
Sorry.
the UMC board is a series of volunteers.
Yeah, that's what I was saying before. It's a not-for-profit. There are no board members that, or,
It has to be focused.
Please,
you know, in any non-for-profit, there are no board, I can speak on behalf of not-for-profit organizations. The boards are completely volunteer. That's what makes it a not-for-profit.
please
Boards don't
limit
serve
your
as
questions to the
organizations.
testimony that's been given tonight. At other nights, there has been testimony about the financing and the costs, but that's been on other times, and that's been recorded, and the videos of all of those hearings are available.
Understood. No further questions.
Thank you. Any other questions for the testimony from this witness?
Closed.
Close the public portion. Mr. Brown, you want to proceed?
Yes, thank you, Ken. Nice to meet you. I call Jim Higgins. As Jim is coming up here, I'd like to do some housekeeping, as I have done when I've been here each time, when I haven't had COVID. At the last couple of hearings, and that would be for April and May, there were exhibits that were introduced, and as I've done in the past, I would ask if they would be marked into evidence, and more particularly, that would be A26 through A30.
Loretta, was that done?
Okay,
Okay.
thank you. Now, Jim, you testified in May. You testified,
I was accepted and
Yeah.
sworn in May. I did
Exactly.
not give any testimony.
you testified just to the extent that you were qualified as an expert.
Right, and then we were going
That's when we
to,
ended.
earlier this month, however, medical issues intervened.
That's correct.
Yeah, and Jim, you had
Yes.
COVID, that's why you couldn't appear on June 1st, is that fair to say?
I didn't want to put people in this
Yeah.
room at risk.
You weren't faking that?
No, no.
Okay.
I can show I actually have on my computer a picture of my test.
Okay.
And the date.
Unless anybody wants to see that, we'll move
No.
on.
I'd be more interested in negative tests from everyone.
Yes, absolutely, Dr. Blumenthal. So, Jim's going to be talking up front about some pictures. So, as I already talked to Loretta about, I'd like to have a series of 6 photographs marked for identification, 31 A through, I think we go up to F, Loretta. So, Jim, without further ado, would you start with your testimony, please?
Yeah, surely. Just so the board is aware, I did review the application. I've reviewed the various plans that have been submitted, as well as the most recent plan that was submitted. I've reviewed the expert reports. I've reviewed the zoning and the master plan, and I visited the site on a number of occasions, and I took pictures of the site on a number of occasions. And I am familiar, being a Monmouth County resident, having driven up exit 114 on the Parkway numerous times. I am familiar with the site, in addition to my familiarity as part of this, reviewing this application. I'm not going to repeat what the application itself is. You've had a great deal of testimony in that regard. I don't think it would really serve any purpose for me to regurgitate that. But I do want to make a point, is that this is a facility for people with dementia, and it's providing a family-style, home-style environment rather than an institutional environment in an area that is basically a residential in character, adjacent to residences. So it's something that's a little bit different than what you would actually view as a typical dementia center, which would be a portion of a larger assisted living facility where a section of that facility is blocked off and people with dementia are kept in there and allowed out on very controlled circumstances, or possibly a completely separate facility again, but it's basically a single building where the people are kept inside the building and allowed out into a small outdoor space to do outdoor activities, again on a very controlled basis. This is a village-type situation where there is controls over the people, but they are allowed to wander, to go out throughout the site, to socialize with other people in in the village that they're in. And it's a completely different concept than that which currently exists either in Holmdel or really any place in the United States, is my understanding. This will be the first of its type in the United States. And it really provides an environment for people with dementia, whether it's Alzheimer's or other forms of dementia, to socialize, to have cognitive activity, physical activity. There's a gym, there's other facilities there. There will be the farm animals for them to go and to look at the farm animals and possibly interact with them. So it's a completely different situation. And what I would like to do is just read to you something from the World Health Organization website that basically describes what I'm talking about. And I'll quote it. It's, quote, "Studies show that people can reduce their risk of cognitive decline and dementia by being physically active, not smoking, avoiding harmful use of alcohol, controlling their weight, eating a healthy diet, and maintaining healthy blood pressure, cholesterol, and blood sugar levels. Additional risk factors include depression, social isolation, low educational attainment, cognitive inactivity, and air pollution." That's basically from the World Health Organization. And this facility really tries to piggyback on that statement and provide for these people activity, physical activity, cognitive activity, eliminate social isolation, so they're not in a house where they're inside enclosed walls with 10 or 15 people. They're in a village situation where they can interact with up to 100 people, maybe a little bit more than 100 people. So it's something that keeps their minds active, and for people with dementia, that's extremely important. It's family style, it's household living, and again, it's residential type situation. In looking at the application itself, it's got a certificate of need, and I think that certificate of need is very important, particularly in light of some of the questions that Mr. Asadi was asking the prior witness. The certificate of need that was approved by the state for this application was an expedited application. And I researched that to find out what that meant. And what an expedited application is, it's determined that the approval would not adversely impact other medical facilities in the region. The certificate of need is a regional document. It's not site-specific. It's specific to a region. And what the state did is they looked at the region, they looked at the demand for this type of facility, they looked at what other facilities were in the region, and determined that approving this facility with a certificate of need would not have any impact on the existing facilities, which says that there is a need in excess of what those existing facilities provide at this point in time. It finds that there's a residential memory support program, assessment program, educational offerings, and extensive community outreach and support. And that's a quote from the certificate of need. And it's regulated by the Department of Health, and also recognizes that the ability of the applicant, which is United Methodist Communities, to ensure the needs are met, because they have over 50 years experience in providing assisted living facilities throughout the state. And I have worked with this organization for well over 20 years, and I can attest to the fact that they do have a number of facilities that operate very nicely, very well throughout the state. When I looked at your ordinances, there was an ordinance adopted in September 2020, ordinance number 2018, and that states, and I'll quote, "Assisted living residences may include dementia, memory care facilities designed to meet the specific needs of persons with Alzheimer's disease or other forms of dementia," unquote. And what this application does, it is designed to meet those specific needs, and it goes beyond what other dementia centers, in my experience, and if the board wanted to go into my experience, I will, but other dementia centers do not provide to the extent that this application will provide. It's going to be a secured, monitored perimeter, not around a building or a small yard, but around a village-type setting, which is very different than any other dementia center that I have ever seen, worked on, or actually seen in my own private life. It has a cafe, has a convenience grocery store for the residents to go, to walk to, and to utilize. And again, these are all things that help these persons with dementia think and helps their cognitive activity, as opposed to having them sit in a room, do little games or whatever, or just go out and do a little bit of gardening in a very enclosed yard. It allows them to go out and think and do things. As an assembly room, a clinic, an exercise and activity center, which is extremely important so that they can get physical activity, administration, and then outdoor gardens and pathways and sidewalks within, again, a village environment. Very, very different than other dementia centers that exist throughout the state. And it's really, it's a situation that allows these residents to feel that they're not being separated from the general public, but that they're within a community, they're within a village-like setting. And again, for people with dementia, that's extremely important that they have that type of social activity, that type of cognitive ability to express themselves and to learn, quite frankly, as opposed to being enclosed in a single building. The site does have a total of 7 buildings in it. There's 11 single-story, single-family home type buildings. They're staffed 24 hours a day. There are 4 residences that are within the 2-story building. That 2-story building is situated as far from the existing residences on the site, or adjacent to the site. There are 6 existing residences adjacent to the site to the north. And that 2-story building is situated as far from those residences as it can be at the way the site is designed, and actually on a downslope after the high point of the site. So it doesn't have a substantial negative impact on those residences. There's a 5th building which has a cafe, a clinic, grocery store, an administration area, the assembly room, and the exercise and the gym area. And then there's a pavilion for the residents to utilize, to go and socialize in. And then there's the barn with the animals in it. The site, I think you've had the site described to you in detail, but what I would like to do is show you some pictures of the site and to describe the use that's on the site, which is currently, it's a garden center that sells bulk materials, mulch, topsoil, stone, firewood, has large bins, has 10 large bins on it, and outdoor piles of materials. And on the site, because it's sells the bulk materials, you have trucks on the site. Those trucks back up, they beep when they back up, so there's noise that affects the surrounding residences as the site currently exists. And then you also have the farm animals on the site, which you've heard testimony that basically, well, it's farm animals, it was there as a hobby rather than a profitable farming business. The site itself, and I'll show you some pictures here, and I think this, let's see, is it coming up? There we go. There we go.
Good.
This is the interior of the site.
Okay, this is the pictures that you...
Yes,
Yes, that's correct.
that
He's
they
going to
marked
refer
into
to the
exhibit.
6 photos.
Right. The last one we'll question, but we'll get to
And
that.
it shows that there's farm equipment, there are trucks. The buildings on the site are very old buildings. They're unattractive.
Who took these pictures?
I took
when-
these pictures.
And when were they taken?
That picture was taken, in mid-May.
May of this
I don't know the
year?
exact date. I can get you the
May
exact date.
2022.
Yeah, that's fine, yeah.
Sometime in the
Yeah.
first half of 2022. is that fair to
First half,
say?
yeah, and it was early to mid-May, I believe.
Okay, so that was after the Potter business had closed,
That's correct.
but the garden business was still
Garden
functional.
business is still there, yes.
Okay.
And it shows, the buildings themselves they're older, they're very unattractive. You have a large gravel paved area, which again is not really attractive. You have trucks on the site, you have a tractor on the site. And then the next one I will show you is a view of the site as you're approaching the site from exit 114. And this is a view, this would be the third picture in your packet.
Yep.
Okay. And it's basically showing the site, what it looks like, all the signage on exit 114 as you're approaching the site, showing one of the buildings on the site. And again, how it's not really that attractive a site. The next picture would be from approaching on exit 114, but from closer. I'm sorry, yeah. And this again shows the site, the buildings on the site, the entrance, the gravel road entering the site, and the fact that it's not really an attractive site as it currently exists. The buildings are old, they're obsolete, and just generally not attractive. The next would be a view from the end of Country View Road looking into the site. Let's see.
Yeah.
And again, it shows that the fencing that's there, which is old, it's somewhat dilapidated. Again, looking at these older buildings on the site, and again, it's not really that attractive a site. And the next one I will show, if I can get it, is this is an aerial, a Google aerial of the site, just showing. And this was from May of 2022. I did not take this, obviously, since it's a Google site. But it's a Google picture. And again, it shows the bins, it shows the piles that are there. These are all closer to the parkway. And in the general location of where the parking would be with this proposed plan. Shows the buildings, and I don't know if I can move this up or not.
So why are you showing us these shots?
What?
Why are you showing
I'm
us
showing these shots to show you what the condition of the site is now. And I will
So
get into
you're
that.
saying it looks like a farm. To me,
No,
that's what a farm is supposed to look like.
I'm saying it's a very unattractive site.
If it's a farm, that's the way it's supposed to look, as far as I know.
That's part of my testimony.
Okay.
Absolutely. Absolutely.
Okay, so you're testifying that it's a farm right now.
I'm testifying that it's not a farm. It's a commercial operation with bins, with piles of materials, selling bulk materials where trucks come in, those trucks load up, they unload, they back up, they beat, they load up, they back up, they beat. And it's an active commercial site.
So, and let me just ask you a few more questions. So you're familiar, as you were going to say, but you bypassed it in your outline for good reason. It's about an 18.55 acre site, right?
That's correct.
And there's about 3 acres that are zoned and taxed commercially. Is that correct?
I don't know if they're zoned commercially. They're permitted.
Right.
It's a pre-existing
Commercial
condition.
use.
Yes, and that's what I'm getting to. Is it a pre-existing non-conforming use?
Yes.
Yeah, okay.
So, and then I have one picture I'll show you later on in my testimony, which goes into the negative criteria. The zoning of the site.
Okay, the last picture in this packet that you gave doesn't look
Yeah.
like it's from this site.
That's not from this site. And
Okay.
I will get to that later in the testimony.
Fine.
Okay. The site is zoned R40B. There are a number of uses that are permitted in this zone. One is that there are single-family detached dwellings at 0.4 units per acre. You could either have them as non-cluster or cluster. And you could have 7 residences based on the density, based on design. I think without variances, you could have 6 for non-cluster and 7 for cluster. So that's one that would be permitted. Other uses that are permitted are public and private schools, libraries, firehouses, and historical museums. Those uses, again, are not residential uses. Then you have agricultural and farms in general, including truck farms, dairy farms, horse farms, nurseries, and fruit farms. And the ordinance also talks about poultry, chicken houses, poultry houses later, so clearly that's also an intended agricultural use. Buildings and structures and premises for use and occupancy by the township for any municipal purposes, and that's a wide range of uses that are permitted. In addition, and this is where it gets very interesting, what is permitted on this site by virtue of the municipal land use law is community residences for developmentally disabled, community shelters for victims of domestic violence, community residences for the terminally ill, and community residences for persons with head injuries. And when you look at the definition of a person with a head injury in the municipal land use law, that is a person who has an injury to their head either by disease or by some sort of physical trauma. And the dementia would qualify as a person with dementia would qualify as a person with a head injury. So that is something that is permitted on this site. And the municipal land use law says the requirements therefore shall be the same as for single-family dwelling units located within such districts.
Mr. Chairman, I have to stop him right there.
This planner is not an expert in dementia, and he's testifying about the nature of dementia in ways that we hadn't heard any of the other witnesses for the applicant testify to. We did not hear a single witness prior to now characterize dementia as a head injury.
All right, well, I'll ask Jim some questions. Would you provide some background of your knowledge in dementia?
Yeah, sure. You heard the prior witness talk about what happens to families with persons with dementia. And this is a little bit difficult for me to talk about, and I will lose my composure, but I will get it back again, I promise you. I was a caregiver for 20 years for a person with dementia. And first of all, everything that the prior witness talked about is true. The impact on the families, the financial impact. I am here tonight because my wife's condition drained my finances, first of all. So that I have to keep working or considerably change my style of living. I think, and the point I'm making is that I have extensive experience firsthand with dementia, with what it is a head injury, and when you look at the definition of the municipal land use law, and I will read it exactly. I have to find it here.
While Jim's looking for that, I can just add, Mr. Chairman, of course, at the end, council is permitted to talk about the legal principles involved. And if Mr. Azadi still contests what is said, there's a very definitive case in the federal court called Blake.
Sandy, can you just pause?
Oh, I'm sorry. Yeah, okay.
You can also listen to me.
I just want to listen.
So if the board agrees, I mean, so there's a discussion, obviously, as to what there's a discussion as to what should be.
Yeah, just for the record, as a public hearing, I respect councils for boards. I'm a board attorney, as you know, but to have private caucuses in the middle of a hearing with individual board members,
It
I was,
wasn't a caucus, it's just, it was either she was
Whatever
going
it
to
is.
say it, or she asked if
I
the
was
chair
speaking
should
for
say
the
it.
attorney,
Right.
Not a caucus, I was speaking to the board attorney.
That's right.
If you'd rather, I'll be public about it, I am certainly.
just making the comment for the record. Thank you.
For your personal experience, I think a lot of people in this room and under this board have had horrible experiences.
Microphone, it's not yours.
Have had horrible experiences with dementia, but that doesn't make you an expert. And we're now at 8 o'clock, and I think that the witness should confine his testimony to his expert, he's a planner, he should talk about planning related things as a witness, because again, Mr. Brown, we are never going to get to, through your application, the rest of our natural lives if we don't move this along.
Respectfully, we are trying to move on this as quickly as we can, and that's one of the reasons
He's
why I
not
made the comment.
he's not a dementia expert, Mr.
Well,
Brown, and
that's
honestly,
your
neither was the
opinion.
other one.
And that's
he's
up
not
to the board to decide, not
qualified-
you. You're not the chairman, and you're not the whole board.
He's not a
respectfully.
qualified expert on dementia. I'm certain everyone on the board would agree.
I agree.
He's a person with
I agree, if you
personal
want me in.
experience that doesn't make him an expert. So that shouldn't be what he's here testifying about, with no
All right, I think let's
disrespect to your
try to move
experience.
along. We each bring our own backgrounds, our own experiences to whatever goes on, and we need to consider that and be considerate of each other. Mr. Higgins is here to testify about the planning function, the need for the variances. He is quoting from the municipal land use law, which is an appropriate thing to quote from, because that's what governs our functioning here. So with those comments, I mean, I can certainly sympathize with you. Our personal experiences often lead to emotional reactions and how we look at things, and we need to consider that and not be inconsiderate of other people in the room. So with that, let's just take a moment and then try to move along so that we can reach some conclusions here.
I have a comment to the previous witness, as well as you. And, you know, again, I feel sorry for your situation or anybody, but keeps bringing up about this being financial. I don't think this facility is going to solve the financial problem of anybody who has somebody with Alzheimer's. It does cost money to go to this facility. So I don't think it's relevant to this application, because it still would have cost you money to have your wife in this facility. It's not being put up for free.
You know, it definitely would have cost money, but there are other hidden costs. We won't get into it because the board doesn't want to get into it. But I will read the definition of a person with a head injury that is in the municipal land use law. And I think everyone in this room would agree that Alzheimer's is an illness, a disease. And the definition of a person with a head injury reads, and I'll quote, "A person who has sustained an injury, illness, or traumatic changes to the skull, the brain contents, or its coverings, which results in a temporary or permanent physiobiological decrease in mental, cognitive, behavioral, social, or physical functioning, which causes partial or total disability," unquote. Very clearly, dementia fits into that, Alzheimer's fits into that, and many of the other causes of dementia fit into that definition.
I have,
Okay.
hi, I have two comments on this line of argument from the planner. The first is that I believe I'm looking at the most recent, the first is that I don't know if this was something the planner was going to get to, but I think it's important for the board's edification, which is that this type of community residence, which would be permitted in any residential zone, is limited to 15 persons. So, you know, if someone were to meet that definition of a community residence, and the same thing for a variety of things, including head injuries, it's not something that can have as many residents as, you know, they want. It's limited to 15 people per MLUL statute. And I would also say, you know, my understanding is that it does not specifically permit dementia, or it's limited to other types of head injuries as well.
Yeah, I wouldn't think that a head injury seems to invoke a different kind of a thought in terms of
Yeah, I mean,
an injury to, from an accident or?
It can be cognitive. It can be cognitive. I think that the more important thing here is that this is, it's a different type of use than what is being proposed here in terms of the number of folks.
And we have one of those facilities with 15 residents.
That's
And the
correct.
issue just came up,
But
whether
it's-
they go 16.
That one's still well.
It's
But-
very clear
Yeah, but that's not limited to dementia.
I'm just saying, it is limited to, that section of the MLU is limited to 15.
Now, in that regard, as long as you're there, the reference to ordinance 2018
Oh.
that he made, now,
Yes.
what was that, does that apply to this zone?
No, that was an ordinance that amended the definition of assisted living. That just the general definition, it did not apply to this zone in particular, it applied to the whole ordinance. And our purpose in doing that was to align the township's definition of assisted living in the zones where it is permitted with the state definition, which includes that sentence about dementia care.
Oh, okay, so the township's ordinance on definition now is consistent with the state and is what he testified about.
Yes, so that ordinance was amended essentially to just to be clear that, modern assisted living facilities, as has been discussed here, often do include a dementia care wing or as this is, qualified, the applicant's proposal is also qualified under an assisted living per the state. So while it's not relevant in this case, because this is a D1 use variance, in the zones where assisted living is permitted, such as the M zone, such as the Route 35 overlay zone, in those cases, it would be permitted to have dementia.
I have a question. The applicant's witness, and I've heard it before, said that this facility is one of a kind in the United States. So that statement has been bothering me because I'd like to know what research was done to determine if the other 49 states in the United States have this. Did somebody investigate this and say there is nothing like this? You checked every facility in the United States and you know that this is the first of its kind? That's the statement that the witness made, that this is the first of its kind in the United States.
Jim, are you relying on prior testimony you've heard?
I'm relying on prior testimony and the information that the applicant has provided me.
Okay, I wish you would have said that, because you're an expert in planning, so what you're saying is what we're supposed to follow as being fact. But nobody has shown me that this is a one-of-a-kind facility in the United States yet.
I think there has been testimony under oath that it is.
There has been, but I haven't heard any proofs of that. Anybody could say whatever they want under oath, but...
No, they can't. They've got to say the truth.
Well, I don't know how they got that answer, that they said there's no other facilities that are in that type of style anywhere in the United States.
Well, respectfully, Mr. Vice Chair, Larry Carlson testified about that twice. He has visited the Amsterdam facility where this project comes from. He has written about it. You heard testimony from Cindy Jakes as well. You heard testimony also.
I heard all that. You're right.
Yes, and also from the chief architect. So they all have personal experience in the field. So he's not, any planner can rely on certainly facts and testimony. That's what this is all about, right?
Okay.
A planner doesn't independently come here with a full scope of knowledge, nor should he. Likewise, in terms of Mr. Asadi's argument that there's a challenge dealing with this type of disease not being associated with what Mr. Asadi says, which is a brain injury. I will provide a case when permitted. It's called Blake Gardens LLC versus NJ 417 Fed Sup 3D, Third Circuit, 493 at 508. That is the definitive case in New Jersey in this area. And in that case, the federal court specifically interpreted the very issues in question and determined categorically that what Mr. Higgins is referring to is the same. And I'm happy to provide that full opinion. And I was going to bring it up at the end of the hearing, but I will happy to offer a comprehensive legal opinion. And as you all know, planners also rely on the law. I mean, he's relying on the MLUL. He will talk to you about the Federal Fair Housing Act. He, as a planner, he is permitted by law to refer to cases. And he is referring to this case. I know that because we talked about it. And
Can I have the name
he's
of the
looking at
case
the case.
again, please?
Pardon?
Blake
Yes.
Gardens?
Yes.
Blake Gardens?
Yes, it's a Freehold Township, a federal case, and it's from 2019.
And what is your statement, what it stands for?
Part of the decision was an interpretation of what Mr. Higgins just talked about.
Well, we've seen it with the other issue that we have unrelated to this. I didn't read it for that purpose, but we actually just had that.
Oh, did you?
Okay. I've seen the case.
Yeah, brain injury
Again,
and dementia.
15 people, though. We're getting it off the topic of.
No, but I his next part of the testimony is going to be not that there is an absolute right as if there was a 15-person house. He's providing a basis, which he's now going to get to. If we thought, like in the Freehold Township case, if we thought that we didn't need a use variance, we wouldn't have been here. We are saying that there's a basis, and I'd ask you to listen to Mr. Hagan because that's his next step here. But it's a building block discussion that he will have with you. And I'd rather have him testify rather than me try to get ahead of myself. If that's respectfully, if that's
look,
okay.
fine. Let me just come back to what Dimitri's comment. Is there anything like this? Proving something doesn't exist can be difficult. I'm not aware of any such other. Does anyone here know of any other similar situation for dementia care of a residential campus? Okay, that doesn't prove it.
We do have something similar down on Stillwell where it's an individual residence where families are living in one building with bedrooms, with joint cooking and backyard and front yards.
Absolutely.
And all the things that you described exist today. I've been there on first aid calls.
Yeah, that's exactly right, Mr. Vice Chair, because that's the classic group home. There's a separate set of statutes under the code dealing with assisted living. That is separate from what we're here about. This is a assisted living facility, not a group home. He referred to the right to develop a home, like you're describing, but again, it's a building block. And again, I ask that Mr. Higgins be able to continue because he'll explain it.
Go ahead.
Okay, thank you very much. And to get back to the fact that the municipal land use law does state that group homes are permitted, and those group homes include residences for persons with head injuries. And I read you the definition in municipal land use law of what a person with a head injury is. Okay. And that there's requirements shall be the same as for single-family dwelling units located within such districts. Now, Kate brought up, yeah, you can have a house with 15 persons in it that have head injuries or some other form of qualifying condition. Okay. But the point I am making is that you can have 7 such houses on this site, because you could subdivide this into 7 single-family lots. Each of those lots could have a building with 15 persons in it. And this is totally coincidental. It was never something that was planned by the applicant, but if you multiply 7 times 15, you come up to 105. And you would have each individual lot would be separate, a separate operation, and you can say, well, that's highly improbable that that would ever happen. But first of all, we're not dealing with what's highly improbable. We're dealing with what the ordinance would permit. And the ordinance would permit that. And as far as the highly improbable, if 3.5, 4 years ago, somebody had come to me and said, somebody wants to come to the Potter Farm and develop it for a 105-bed assisted living facility for persons with dementia, I would have said that's highly improbable. So the highly improbable does happen. And really the standard, the legal standard is what does the ordinance permit and how different is what the applicant is proposing, how different is that from what the ordinance permits. And the ordinance does permit facilities for persons with disabilities, including head injuries, for up to 105 people in 7 separate dwellings. And you could have a cluster subdivision, and that could happen on this site according to the zoning. And what the applicant is proposing is basically a cluster development with, instead of 7 units with 15 people, it's proposing 15 units with 7 people. So it's not that far off from what the ordinance would otherwise permit. And that was the one point I wanted to make. Now, a D1 variance is necessary because this is not something, because of its configuration, because of the amenities and the facilities that are within this development are not permitted in the zone. So you do have a D1 variance that's required. But one of the things that we have to show is how different is this from what the zone would permit, and how different, how much more or less intense is this than what the zone would permit. And that was the point I was getting to on that issue. As far as the D1 variance, you have the positive criteria, and very clearly in this instance, the positive criteria is that the use is inherently beneficial. There's absolutely no question about that. It meets the definition of an inherently beneficial use in the municipal land use law, and it's basically a case law, I think, that would also establish this as an inherently beneficial use. You've had, with inherently beneficial uses, you have the Sika case, which I'm assuming as a zoning board you have had that described to you. And in Sika, which was a 1991 case in Holmdel Township, the Supreme Court established a 4-part test to determine whether or not the use should be permitted. And so the board is aware. I am intimately familiar with the Sika case. I was Dr. Sika's planner. So I know that case very, very well. The first step in determining whether or not the use should be permitted is determining the magnitude of the benefit that the applicant is proposing. And here, first of all, you do have, as I said earlier, a certificate of need. That is an expedited certificate of need that, in order to be expedited, it has to be demonstrated that there is a need for that use that is in excess of the need that is being met in the area, so that there will be no detriment to existing facilities of this nature in the region in which that is covered by the certificate of need. So very clearly there is a need that exceeds what is being provided at this point in time within the region. Okay? We've heard testimony about the facilities and how the unique facilities that are available at this facility. And again, those I think go towards demonstrating again that there is a substantial benefit to the granting of this application. You have 105 people that will be benefited by it, and plus their families. There is a need for it as established by the certificate of need, and so when I look at this, I think very clearly there is a substantial benefit involved. Also, you have other benefits that go along with that, are the fact that 10% of the units of the beds in this facility will be for people on Medicaid. Those units will not only benefit people that are extremely that don't have the income that would otherwise enable them to use the facility, but also they would qualify as affordable housing units. And because they are rental units, the township would get double the benefits. So instead of having 10 or 11 units credit towards their affordable housing plan, they would have 22. That could be applied either to the current third round or to the next round of affordable housing. So there's a substantial benefit there also.
Next round, 2025?
I think it's 2025, that's correct. That's correct. So when I look at that, I think, looking at everything, I think, as I've described, the amenities at the site, the fact that it's benefiting 105 people, and 105 families, really, not 105 people, 105 families, and that the township would be getting the benefit of up to 22 affordable housing credits. I think there's a substantial benefit to the granting of this application. In addition, another test for the positive criteria is whether or not a site is particularly suited. And we don't really have to show that in this instance since they're inherently beneficial. But I think it helps to look at this site. And you see, it's an 18-plus acre site. It's adjacent to the parkway, across from exit 114, so it has adequate access for persons who either work there, want to visit there. So I think in terms of its location, in terms of its size, it's large enough, more than large enough to accommodate the proposed use. It's allowing the clustering of the buildings. It's allowing substantial areas around the perimeter of the site to provide buffering, provide landscaping, and to separate the site to the extent that the board and the neighbors feel is necessary from the adjacent neighbors, and more than adequate road frontage. And again, there's a certificate of need specific to the area. All of these things go to the particular suitability of the site. So I think the site is also particularly suited, although that I think is trumped by the fact that the use itself is inherently beneficial and is has substantial benefits to it. We then look at, and there's one other point that I think also goes towards the benefit, and that is that the persons that with dementia are protected under the Federal Fair Housing Act. And those protections allow them to live in the neighborhood of their choice within the community, and they require that municipalities make, quote, reasonable accommodation for housing for protected persons. And reasonable accommodation means not only that there has to be legislative actions such as ordinances that would allow the use, but administrative actions such as granting waivers or variances that are necessary to allow the use to be in residential areas. And that, again, is reinforced by the Blake Gardens decision, which Mr. Brown talked about before. Clearly, the approval will be a reasonable accommodation that's necessary to afford the persons with dementia equal opportunity to enjoy a dwelling in a location of their choice. With regard to negative impacts, that's step 2 of the CPIC test, is determining whether or not the magnitude of any potentially negative impacts from the proposed use as compared with permitted uses. And again, that's comparing with what's permitted in the zone. And potential negative impacts include noise, aesthetics, traffic, and safety. With regard to aesthetics, again, the existing view of the site, and this goes back to the pictures I was showing you, the existing view of the site is really one of a very unattractive agricultural use, if you want to call it that, but it's really a commercial use. And the buildings are unattractive, and by comparison, what's going to be proposed are going to be very attractive buildings with substantial landscaping. It's going to significantly improve the appearance and the function of the site. You have rundown commercial buildings, old pavement, you have the trucks, you have the unattractive fencing, and as you saw the view from Country View Road, it's very unattractive as you view it from that side of the site. So in terms of aesthetics, I think what's being proposed here is much better than what exists. And let's look at what could be permitted under your zoning. And this is where it gets really interesting. First of all, the scale that's being proposed is substantially consistent with what would be permitted by your ordinance. As I said, you could have 7 houses here with 15 occupants each that could provide different types of assistance for different types of conditions, or they could all be for persons with head injuries. It would just be 7 separate sites. I'm drying up here. Okay, you have, first of all, single-family, non-cluster, where you would have a permitted coverage in terms of impervious of 15% on each lot, or single-family cluster, which would allow 25% coverage. And I think it's important here to look at the fact that there is no one lot coverage, impervious coverage requirement for all uses in this zone. There are different impervious requirements for different uses. And I know Kate has talked about the fact that the 15%, and we exceed the 15%, but that's limited to single-family, non-cluster development, churches, and several other of the permitted uses in the zone. Municipal uses, I think, that's not limited to municipal uses. The other uses that are permitted are farms and nursing homes. And nursing homes aren't permitted, but nursing homes are permitted on a 5-acre minimum in the lot. So I don't know if the ordinance has been corrected to that effect or not, because nursing homes technically are not permitted in the zone. But, okay, and maximum building height shall be 30 feet, and the maximum building coverage for farms shall be 15%, except that barns shall not exceed 50 feet. And minimum setbacks shall be 100 feet from all property lines. So you could have a barn that covers 15% of the site, and I will get into that specifically in a couple minutes, and be 100 feet from the property lines. You could also have farm equipment that can be stored and parked 50 feet from property lines, as compared to this development, which has 100-foot buffers and basically buildings that are residential in character. The farms can generate significant noise during the early morning hours. You have a poultry farm, particularly chickens, they can make a lot of noise in the early morning hours. You could have a chicken coop that could be 50 feet high, according to the way your ordinance reads, 100 feet from the property line. And that building could be getting there, and I apologize. Okay. It could be 120,000 square feet in area. You could have a barn on this site. It could be 120,000 square feet in area. And it could be 50 feet high, 100 feet from the property line, and it could have silos that exceed that 50 foot by 12.5 feet. And they can be constructed without benefit of a site plan. So, yeah, agricultural uses are permitted on the site. You heard Bill Potter talk about the fact that passive, lower intensity agricultural uses are not appropriate because the site's too small. So you would have much more intense agricultural uses on the site if Mr. Potter's testimony was correct. And you could have barns 50 foot high with silos 62.5 feet high. You'd have total of 120,000 square feet of building at 15% of the lot area, and 100 feet from the property line without site plan. And you could have farm equipment located 50 feet from the property line. That's a substantial impact on the surrounding properties and substantially more intensive than what the applicant's proposing. You could have municipal facilities at the site. You could have parks, playgrounds, you could have community buildings. There are no standards in the ordinance to govern those buildings, that type of development. So they could be constructed on the site with coverages that exceed 15 or 25%, because there are no standards in the ordinance that cover those developments. And again, those could be much more intensive. You could have recreational facilities on the site with night lighting. You could have impact on the adjacent residences. And again, it's a site with great access, so it would be ideal for that. And it's an 18-acre site, so you could have a number of facilities. The points I'm trying to make here is that what can be constructed in this zone is more than just single-family residences and much more intensive uses than single-family residences and much more intensive uses than what the applicant is proposing. And the applicant is proposing, again, something that's much more similar than what would be permitted by right on the zone with the 7 houses with 15 people in them as opposed to the 15 residences with 7 people in them. So when I look at the negative impact as far as those things go, I don't think there's any substantial negative impact. With regard to noise, this is residential use. The only issue that really has been raised at all was the generator, and there is a noise report that has been submitted, and that report basically shows
Let's just hold on. This would be the last exhibit that we would propose, A32 for identification.
I think that was previously sent to the board members.
Yes, it was, yeah, under the 10-day rule. And Jim, you've looked at that noise report, have you not?
Yes, I did.
Yeah.
And basically the conclusion there is that it most likely as proposed, the sound levels at this property line will comply with state standards. And if they are measured afterwards and they note that additional buffering, sound buffering will be provided so that they do meet state standards. With regard to traffic, we've had extensive testimony on traffic, and I'll rely on the traffic engineer's testimony as far as that goes to say that there is no substantial negative impact as far as traffic. And other than that, as far as safety, there's no issues that I can see with regard to safety. I don't think there's been any testimony that there are any negative issues with regard to safety. You have a fully enclosed perimeter of the village portion of the site. It's controlled, it's monitored, so that people aren't going to wander out of the facility. In fact, it's probably better than a situation where persons with dementia are in their homes and you have somebody that's a caregiver who's overworked and stressed out and can't possibly monitor a person, particularly somebody with severe dementia, to the extent that they would be monitored in this facility. So, if anything, this is a better alternative.
And Jim, also,
people in private residences.
in terms of traffic, also the proposal would eliminate the possible expansion of country clubs.
That's a very important thing. Right now, the way the site is situated, you could extend Country View Road through to Red Hill Road and have that go right through the site and be opposite the exit 114 lane from the site, from the parkway. And that is something that, in my opinion, is not desirable, and I'm not saying it is a scare tactic. It's a very real possibility if somebody wants to come in and develop this site for single-family residential purposes, and if they have a fully conforming application, it couldn't be stopped. So that I think is extremely important. And I think, again, what's being proposed here is a much better alternative. You have a village-style development with, for the most part, one-story homes. You have one two-story building that is situated as far from the adjacent residences as it can possibly be done. The parking is located adjacent to the parkway, so that isn't an issue in terms of the adjacent residences. And I think what's being proposed here is a far superior planning alternative. In terms of once the magnitude of potentially negative impacts is determined, and they've been discussed at length in the prior hearings, the applicant has responded to them in terms of additional buffering, in terms of providing for basins, drainage basins that are adequate and are buffered, with regard to putting a pump station underground so that's not visible. All of those aspects eliminate any of the potential negative impacts. And then the final part of the test is looking at the application to determine a balancing between the positive impacts of the application, the magnitude of the benefit, and weighing that against any negative impacts. And that's where the test gets very interesting, because you're used to saying, well, if the benefits don't substantially outweigh the detriments, then you shouldn't approve the application. And what SECA says is that the detriments, if the detriments don't substantially outweigh the benefits, then the application should be approved, because it's an inherently beneficial use. And here you have a situation where, in my opinion, as a professional planner, the benefits substantially outweigh the detriments. The applicant has worked with the board and has anticipated all the potential negative impacts that the board has brought up and has responded to them. And what's being proposed here is an application that will have minimal negative impact on the municipality, is much less intensive than many of the permitted zoning uses, is somewhat consistent with what would be permitted by right on the site, so that there are no substantial negative impacts and there are very substantial benefits. So when I look at that, I think the application should be approved.
Jim, you will also have looked at this in terms of bulk variances, right?
Yes, I did.
And could you provide a short summary?
Yeah, sure, yeah. Basically, first of all, the courts have been very clear that when you have a use variance and that the use is not one that's permitted in the zone, that the bulks are subsumed within the use. The board should look at what's being proposed in terms of bulks, but they're subsumed within the use. In this case, I don't think there are any bulk variances necessary. I know Kate has raised the issue that the impervious coverage is greater than the 15% permitted for a single family non-cluster development. But that's only for a single family non-cluster development. You have other uses that are principal permitted uses in the site that don't even have standards for coverage, for impervious coverage. Agricultural uses have a standard for building coverage, but not for impervious coverage. So for this use, there really is no standard for impervious coverage. And in the event that the board wants to say that, well, the standard is 15% and the applicant's proposing approximately 23%, again, that goes to the fact that this is a use that's different than a standalone single-family house. It's a cluster-type development with amenities other than we would find with a single-family house. You have the pavilion, you have the building that has the administration, the gym, and so on. You have walkways throughout the site to allow the residents of the site to walk around the site freely, so that all those are issues that go specifically to the use and should be considered by the board, rather than looking at a standard that really doesn't, it applies to a use that isn't being proposed. So if the board feels that bulk variance is necessary, again, it's subsumed within the use, and I think it's appropriate.
Very good. And in the terms of design waivers, how does that apply to bulk variances?
Same thing. Design waivers would be subsumed within the use again, because they're not geared towards this specific use.
Okay.
And this use is different than a single-family standalone lot.
Also, Jim, and as a planner, do you have an opinion on the site plan application, which is for preliminary and final site plan?
Well, my whole testimony has been pretty much based on that site plan that is before the board, and I think it's appropriate. I think it fits this use perfectly, and again, the issues are aesthetics, and there's substantial landscaping that's being proposed. The buildings are in scale, they're a residential scale. The drainage is, as I understand it, and the engineers will have to confirm that, the drainage is adequate. You have adequate facilities on the site, you have adequate access, and so I have no problem at all with the site plan.
And your final professional opinion is, should the board grant preliminary and final site plan?
Yes.
No further questions or testimony on direct by Mr. Higgins.
Okay, Kate, would you like to, as our planner, comment on the testimony we've just heard?
Sure. Thank you, Mr. Chairman. Just going to start with the item that was just brought up regarding the bulk C variance and the impervious coverage. So Mr. Higgins' point is well taken in that if you read the ordinance at its bare technicality, it does not, since this use is not identified in there, it does not provide a impervious coverage calculation for that use. And so, I tend to agree that, this was misread at some point by myself, by whomever, and so that may not be valid as a actual separate C variance. And again, Mr. Higgins' argument about variances being subsumed within a use variance is also very salient here. However, I think that one thing for the board to consider is that even if it's not looked at as granting a separate C variance for impervious coverage, I think that what's being proposed here, and this is not, just no matter what number it is, I think that that's something the board can take into consideration as part of their overall review of the subject property. And just for example, if the situation that Mr. Higgins has described, where there were to be 7 community residences, those would all be considered to be single-family homes and would either be 15% impervious coverage or 25% if it was cluster, but then there would be a whole separate open space area. So, just to say that it does apply to those types of uses in this zone. And the other thing is, I think for the board to look at is just considering the overall character of and the purpose of the R40B district, and because the R40B is really distinct from the R40A, is that these are more sensitive areas. Not every single acre of it, or not every single parcel is going to be more sensitive than something in the R40A, but as the whole, this zone was the zone was derived in order to, meet the needs of these sensitive sites, whether it's the watershed, whether it's the soils, whether it's whatever the situation on any given lot might be. So I think in that case, the board, and this has already been discussed by the applicant's engineers, you've heard that testimony about stormwater, et cetera, but I think that whether it's a specific variance, I think that the impervious coverage is something that can still be considered by this board.
Then, would you comment also on the testimony that 7 group homes would be permitted?
Yes, per the reading. I have to admit that I did. This is what happens when you prep for over the course of a year for a hearing. Yeah. I did forget about that federal case, which I am very well aware of. So yeah, the MLUL did read for a while, and it might still on paper, that group homes are not, or that dementia is not considered a head injury, but the federal courts have ruled against that. So yes, so it would be permitted in the sense that if they were 7 homes. I think that, I think that there's a couple ways to look at that. The first is just that, yes, that use would be permitted on 7 lots by the very letter of the case law and by the letter of the MLUL. I think in terms of how it's applicable here is what's the difference between how 7 individual properties that all are constructed to look like single-family homes might differ in both access, in utilization, in just in how it operates differently from what's being proposed here. And there's that can go both ways. As Mr. Higgins mentioned, if there were to be a residential subdivision here, there would be the possibility that it connected through to Country View Road. And this applicant has indicated that they would put a deed restriction on the property, that would not be the case. But on the other hand, it would, this is proposing to function as one cohesive unit. So I think that it's an interesting argument, especially because in how the numbers do happen to work out that way. But it is those are facilities that are intended to function as separate single-family dwellings, which is not what's being proposed here.
Correct me if I'm wrong, but on their site plan, they have a town center and a pavilion. If it was subdivided, we only have, right?
Yes.
So there are 2 additional buildings.
Yes, and there would not be things like a large parking area, or it would just function in a different way. But there could be that number of residents based on the statute and the case law.
So in your opinion, if somebody did apply for that type of development there, compared to what is proposed, which one would be more detrimental to the neighborhood or not?
It would be, it's hard to say that without looking at what a specific proposal would be. For example, would these be 4,000 square foot homes, or would they be 10,000 square foot homes? How tall would each of them be? I think that you have to look at whether something would operate as a, there's differences that are associated with single-family style dwellings, which their single-family style is what these type of residences would be, but they're not definitively single-family. So I think it's a matter of scale, it's a matter of layout, because in that type of situation, if it was cluster, there could be more open space. If it's non-cluster, there could be less open space. But I think, you have to look at things like whether it would connect into the internal subdivision behind it, which this applicant's not proposing to do. But on the other hand, this does have extra buildings. It has a parking area. It has a, it has sort of buildings that do connect in ways that make larger buildings. So those are, it's like you can't, I can't specifically give my opinion without knowing what what the other option would specifically look like, but those are the types of things that you would consider. The overall scale of the buildings, the size of the buildings, et cetera.
Do you have any other comments on Mr. Higgins' testimony?
The only other comment, and this is probably mostly for Marty, but I think that there is still one outstanding Bulk C variance, which has to do with signage. And I know that the applicant, we've talked about it, the applicant has indicated that they do want to sign. And again, this goes to the technicality of the ordinance. This is a residential zone, so signage such as this, the type of sign you would want is not contemplated here. So a C variance is technically permitted.
And then there was one with regard to landscaping as well. That was really a waiver.
It was a waiver of a checklist item, yeah, which I think testimony has been provided on that.
That's much further down the list.
Yeah.
Kate, if they were going to be able to build 6 or 7 single-family homes, what would the square footage be permitted of each of those homes? What would be permitted in the zone?
There's not an FAR. They would be really limited by the lot coverage requirements, including impervious. They would be limited by their setbacks. They would, just really be limited by the density of the property.
I thought somebody said 0.4 of an acre, right?
What's that?
I thought they had mentioned, is that right?
No, it's density.
That's the density. That's not FAR. So
Okay.
that's how you get the calculation of 6 if it's non-clustered, 7 if it's clustered.
Clustered if it was
Yes.
7.
But yeah, and I mean, there's other sections of the ordinance that do, regulate what, to a certain extent, if it's not giving a floor area ratio, it's not giving a maximum square footage, they do still, any building, any residential or residential style building would have to meet certain requirements, namely in this case, the impervious coverage.
It means I'm just trying to decide, obviously, idea put out there that if they wanted, right, if we weren't going to do this, they could build 6 or 7 individual homes and put up to 15 residents in each home without our consent, right? They could do that as a matter of right. So I'm wondering how big a house that would have to be to house 15 people, and whether that would even be possible on that lot size that they were proposing.
I can't say without doing a specific analysis. I think it would be difficult, especially in a cluster zone where the lot size is smaller. But yeah, all other aspects of the ordinance besides the use would still apply there.
Jim has done that statistical study, if you think it's helpful, Kate.
Yeah, I have those figures. I glossed over that.
I'd be curious. I mean, I don't want to say it was a threat. It was an idea put out there that you could do this over our
I can answer those questions.
Okay, I'd be interested.
Okay, if it's a single family, non-cluster, the minimum lot area is 108,900 square feet. The impervious lot coverage permitted is 15%. That's not building, that's total impervious.
Okay.
So I took a figure of 7% building coverage, leaving 8% for other impervious coverage on the site. And that comes out to a footprint of 7,600 square feet. And if you choose 2 stories, it's over 15,000 square foot of building. That's on a non-cluster. On a cluster, which permits minimum 43,000 square foot lots and 25% impervious coverage, I took 15% for building coverage, and that comes out to 6,450 square feet, basically coverage and a possibility of 12,000, almost 13,000 square feet per house. And just one other comparison, the total square footage provided by the applicant in this application of the buildings, all the buildings, is 83,000 square feet. If you look at the cluster provisions I just gave you, the total square footage that would be possible would be 84,000 square feet in all of the buildings.
Okay. Thank you.
Valerie, I'd also just one more note on that is that, these are, that sounds correct to me. It's based, explicit, it's based strictly on the zoning, but this, every site is different, and every site has slopes, every site has different types of, without looking at from the perspective and what kind of infrastructure would you need to have this. You might lose some site area if you had to have a roadway or something. So, those numbers sound very high, and I don't know what the needs are for something like this.
Right. Well, they need a roadway.
Yes.
All the houses would have to be legally conforming single-family homes. They'd have to have garages. They'd have to have driveways.
Septic systems. Septic.
Yeah, you'd have to look at, there's slopes in the rear of the property,
Steep slopes.
Yes. So those would have to be avoided, conservation easement, everything that we're looking at here. So, I just those numbers.
You might not get 7 houses there.
Right. And,
you might only get 5.
And I don't know that offhand, but so that I think is just one, just a caveat to Mr. Higgins'
But it is interesting to note that some of those options could be done by right without coming to any of the boards.
No, they'd have to go to planning board.
No, Stillwell did not, remember? They didn't.
No.
They bypassed the board.
It's by right.
completely.
Yeah, but this is a
Stillwell-
whole.
They would have to go to the board for the subdivision
Yeah, the
itself,
subdivision.
but they would not have to go, they would not be treated any differently than if they were building single-family homes for families.
Right.
Just remember that we don't have that application before.
No,
us, so it's-
exactly.
Correct.
We're
Exactly.
speculating. It's an interesting concept for the board members to
Well,
consider,
well,
but don't.
the applicant's planner brought it up as what they could do if they didn't have permission, right? So I was just considering what they could do without our permission, so.
That's
they
open for
raised these.
discussion.
Yeah, and we're not, again, we're not here to evaluate that
Nope,
on its merit.
Just wanted to have an idea.
Yeah. Okay, do any of the board members have other questions on Mr. Higgins' testimony at this point?
I had a question. So in terms of group home versus assisted living facility, what are some of the overlaps and some of the differences in terms of needs and in terms of, caretaker to patient, needs and ratios and things like that? Is there a difference? Is there any I'm trying to draw, because this Blake Gardens case you're saying is about group home, correct? And then
Yes.
you're suggesting it's just a living facility, so.
Blake Gardens was for a single facility.
Correct.
Standalone, for persons with dementia.
Correct.
And Blake Gardens is a chain. It's
Right.
not, in fact, there's one in Holmdel.
Right, so my question
yes,
being,
yeah.
what are the similarities and differences between the two categories, if you will?
And I don't know. I'm assuming that there's again, a certificate of need. In fact, I know there's a certificate of need for each. And I would only be guessing as to whether or not the standards are the same.
Doctor, of course, we've been before the board since September. There's been a lot of testimony, and it's been a long time, I know, but there was testimony by Mr. Carlson on that, especially by Cindy Jakes. And for the benefit of those who might want to dig into facts like this, I will offer a detailed outline which will refer to every provision and every transcript on every point that you're talking about, as well as really any others that were alluded to by Mr. Higgins and which you may have an interest in, if that's helpful.
The reason I asked that question is because the application that's in front of us is about an assisted living facility for 105 individuals. And I understand the case law, I'm not, legally inclined, if you will, but, just from a healthcare standpoint, I worry about that. I think about those things rather about the ratios and how that affects outcomes for patients and things of that sort. So that's why it's an interest. And I think, to go off of Mr. Flieger's comments, it's a totally different application in that sense to me.
Yeah, and if I remember correctly, Doctor, we had that dialogue with Cindy Jakes before. Correct. You were very concerned about the ratios involved.
Correct.
And again, I can go into that. I don't know if you'd like to, or I can send you the transcripts. But that was specifically addressed on more than one occasion. I can talk to you about compliance with the regulations, compliance with the assisted living provisions, compliance with the CON.
Of course, no.
Yeah.
Again, I'm just saying, my only concern is that a group home, it would be a totally different application for this in front of us then.
Yeah,
Correct.
and our point, in part, is that this is a better way to take care of those with dementia. Yeah.
Sure.
Mm-hmm.
Bob, all of this has been planning rather than engineering, but sometimes since the site plan is mostly engineering, but do you have any questions or comments on what we've heard so far?
Well, I did want to add earlier, but I think it's been addressed. When you talk about the residential option, whether it's clustered or non-clustered, and the impervious coverage limit of 15%, that does not necessarily include the roadway, the sidewalks, and so on.
Yeah.
So that 15% gets artificially higher when you do include those services.
Okay.
Yeah. So in other words, Bob, if you had a cluster, which that's 25%, if you had a roadway through from Country View, or if you have the individual roads, that's not part of the 25%. Would that be correct?
Correct.
Yeah.
The 25% or 15% is on the individual lots.
Exactly. Yeah.
Mm-hmm. Yeah, because the roads are outside of that.
That's right. Yeah. And of course that adds really to the impervious, but it's not counted.
Do board members have any other questions about Mr. Higgins' testimony so far? We have this night.
Mr. Chairman, before we go outside, there are just 2 points that Jim would like to clarify. It goes to our vice chair's question about 5 versus 7. Jim, why do you have a confidence level that 7 could be permitted in light of your understanding of the planning and the studies you did?
In light of I've actually looked at a cluster subdivision of the site that I think would take into account all of those concerns. And
all the ones mentioned, including topography and the like, that was...
Because the cluster size is less than, the lot size is less than half the size of a non-cluster. It's 43,000 as opposed to 108,900. So when you cluster it down, you would not have the issues of the steep slopes or any of the environmental aspects.
And also,
In terms of the discussion about, the proposed 15 houses and the like compared to what could be a cluster residential subdivision, that was all in terms of what's permitted under the zoning, right?
That's correct.
But also, just to clarify, you also talked about a lot of other uses that are not residential, which
Yes.
are permitted. Why is that relevant, the other uses?
Well, because those uses, that's in terms of the negative impact of what the applicant is proposing and how what's being proposed has much less negative impact, much less impact on surrounding properties than what could be developed as of right on the site.
And that's good, because negative impact under the SECA standards is relevant for consideration of an application like this?
That's correct.
Thank you.
Okay. Any other board member questions of Mr. Higgins' testimony? Well, we've been going for a couple of hours. I think it's appropriate to take a 5-minute health break.
What
And
time
then
do
we'll
we propose
continue.
to
We'll
end
come
this?
back at,
It's 9 o'clock. What are you proposing to end this?
Well, you
To get to
discussed the last time that you allowed tonight to go a little later.
Yeah.
So we can try to wrap that up.
So I can try to assist in Dimitri's question. The only other witness that I would recall would be Hal Simoff. It was mentioned last time that he was going to provide some information, a final study. He's done that. I would submit that it's not required for him to testify, but he is here. And I know he's talked to Mr. Mullen, and if there's some kind of consensus of the engineers about what can be granted with conditions subsequent, that's where I would like to go. But again, he's here to the extent that anybody needs to ask him any questions.
Let's maybe try to go 1 hour. I think it's appropriate to put the additional submittals on the record.
Okay.
And so let's say, it's 9 o'clock, let's resume at 9:10.
Who's stopping, though? We haven't heard that yet. 10 o'clock?
Yeah, I just said 10.
10?
Let's try to go for
Everybody's
10.
good 10 with 10?
Yeah,
Okay.
okay.
Yes.
The continued public hearing on the Dementia Center application. And let's see, Mr. Higgins has completed his testimony. Board members have...
So I have one clarification from the attorney. And if there was a sixth photo, we never testified to it, or we... A sixth photo, is that, should be part of the record, or we gotta take that out?
Yeah, he should mention that briefly. That's
Yeah, that sixth photo is just simply to show the board what a farm can look like on this site. That's the Disbrow Farm in Monroe Township.
You have a picture?
But it's just simply to show that a farm does not necessarily have to be an attractive facility, and in fact, on a small site like this, I don't believe it would be.
Is that the ice building?
It's in Monroe Township.
You took that photo?
I took that photo.
Same time frame as you discussed before?
Yes, yes.
Thank you.
Okay. Then, before going to questions on Mr. Higgins' testimony, I think you wanted to briefly have Mr. Simoff testify and put on the record the additional information the board has received.
Sure.
Why don't we just take a couple of minutes to do that? In short, the board has received updated stormwater plans and related documents from the applicant. And so, Mr. Simoff, you continue to be under oath, and you want to just briefly describe what has been submitted?
Yes, at the last meeting that I attended, and I can't recall when that was, May, I submitted a concept plan of the drainage areas and the drainage basins.
And that was 8:30?
If you say so.
It was.
So I submitted the concept in order for the drainage basins and the drainage areas to conform to the latest stormwater management rules. And then in the interim, it was 10 days ago, we submitted a report with soil logs and designs that show how we will implement the specifics of that design. I might just add one more comment. I had a meeting with Bob Mullen yesterday, and we propose infiltration basins, which we can do, and we can meet the ordinance by doing it. But there was a comment or a suggestion that we revise it to rain gardens, which I've spoken to the client, and we're willing to change the basins from infiltration basins to rain gardens where it works. There's a requirement to have the distance from the bottom of the basin to the seasonal high water table, and we conform to that now. But if we have rain gardens and we can do it with the same separation, the client has agreed to do that. So we would make that a condition. We would suggest that it be a condition of the approval.
Right, Mr. Chair, to expand on that, so our request is that the board consider granting preliminary and final site plan in relationship to the engineering he's referring to, and we would agree to any conditions subsequent that would be recommended by Mr. Mullen. We would be under his control, if you will, in terms of satisfaction.
Now, what my understanding, correct me if I'm wrong, is that the main change in this revised stormwater management plan is to have an additional basin, which is consistent with the latest stormwater regs from the state, where they want one basin to only serve 2.5 acres, I think that, or something like that. So you've added a basin. The total area being dealt with is still approximately the same, but it's slightly differently configured.
Correct.
Would you just comment on what the effective difference between a infiltration basin and a rain garden is?
The infiltration basin has a layer of sand at the bottom that that would drain into the soil. I might add that in basins C and D, we did one of the tests of the report is that you have to show what happens if the pipe gets clogged, the outfall pipe. And basins C and D have been designed, and we're lucky to have the soil types, that if the basin, there would be no overflow from that basin of the 100-year storm, it would all infiltrate into the soil. But A and B would have an overflow on the spillway. But the intent is to design it to maximize the infiltration. Now, an infiltration basin just has a layer of sand at the bottom. Rain garden has subsurface drains.
Moreover, an infiltration basin, correct me again if I'm wrong, looks like a basin,
Correct.
whereas a rain garden looks more like a garden.
Yes.
So it serves the same function, but is more attractive?
Yes, and the client has agreed to do, it's more expensive, but the client has agreed.
Okay, Bob, what comments do you have about the latest version of the stormwater things, rules?
As Mr. Brown indicated, we did meet with Mr. Simoff yesterday and went through the revised plans and the revised stormwater report. The plans matched the concept that was provided to us 6 weeks ago, whatever it was, in that they redistributed the basins. They added an extra basin to reduce the drainage area contributing to each one. And as Mr. Simoff had indicated, the three larger of the what are called small-scale basins were just sand bottoms. And we recommended, and they've concurred, to convert those to bioretention or rain gardens that are aesthetically pleasing. There's more maintenance required because they are landscaped, but it's not going to look like a beach. And a year from now, it's not going to look like a beach with weeds growing through it. It'll be landscaped. It'll be well thought out. The landscaping will be prepared by a certified landscape architect, not just some engineer. So,
well, I mean, for those who are not familiar with it, it's, I guess, maybe 4 or 5 years ago now that the inner courtyard at the village school was converted from an open area, which didn't look very exciting, to a rain garden to absorb the roof drainage and with extensive landscaping that the kids were involved with. And it's continued to be there, and it's a much more attractive site than what used to be there. And if you don't know what a rain garden looks like, take a look at the courtyard at Village School. And it's the trend of what the state wants. You want the water to infiltrate instead of running off, creating flooding, and to be more attractive. It's the greener way of doing things. Okay.
And that's exactly what I was going to add, Mr. Chairman. It's those bioretention basins, rain gardens qualify as green infrastructure under the state's new regs. And it does do a better job treating the water before it infiltrates and gets back into the groundwater.
So that, as I looked at the summary in the report, the runoff from the site is significant and consistent with the state rules, is significantly reduced from what happens at present.
That's correct. The rate of runoff.
Yes.
And we've adjusted the direction so that we've minimized the runoff to Wackack Creek. There's virtually nothing. There's no of the impervious area that's collected in our basins goes to Wackack Creek. It all goes to the county system and heads east rather than south.
And it's Wackack which leads to the flooding on Palmer Avenue. Okay. Any other questions? Do you have anything else that you want?
Well, one more quick point. This, there was discussion that I heard about the dividing into 6 or 7 or 8 single-family lots. This is a more positive way of handling the drainage because it's maintained by the applicant. There's going to be a stormwater management report or a maintenance report that's submitted that the applicant has to adhere to, and versus doing 5 or 6 or 7 individual lots where the drainage is handled individually. So this method of drainage is a better solution than dividing it into single-family homes.
Well, okay. Is that it, Mr.
That's
Hashimo? Okay, good. Thank you. In that case, with the board's consent, we'll open to public questions on the testimony Mr. Simoff gave and Mr. Higgins for tonight. So, members of the public who have any questions about tonight's testimony by on engineering, on the drainage for Mr. Simoff, and on the planning for Mr. Higgins? Is there anybody in the members of the public who have questions? Questions, not comments. We'll get to comments another evening, hopefully. Okay, you want to identify yourself for the record, please?
Kevin Asadi, Zager Fuchs. My questions are all going to be for Mr. Higgins. I'm going to start, Mr. Higgins, asking you the same questions that I had asked Mr. Zanes, just to be thorough and make sure we don't have certain information. Do you know how many licensed memory or dementia care facilities are in New Jersey?
In New Jersey, no.
Do you know the answer to that question just relative to Monmouth and/or Middlesex counties?
No.
Do you know how many beds are currently available in Monmouth and Middlesex counties?
No.
Are you aware of other sites in Holmdel where this kind of facility would have been permitted as a permitted or conditional use?
There's,
did I say sites? I meant zones. I'm sorry.
Zones. There is one zone in the township where it is permitted as a permitted use, I believe it is. It's the RT35H overlay zone. That is a zone that is, first of all, very intensely commercial. I looked at that zone. I looked at every site in that zone, and there is only one site in that zone that is available, that is vacant, is quote vacant, and would be available for development. That is a 7.5 acre site on Route 35 that is currently farmed and farmland assessed, and it has been farmed and farmland assessed for many, many years. I checked the tax records. It's 7.5 acres, and it really is not appropriate for this specific type of development, both because of its small size, because it's in an area that is not single-family residential in character, and as I said, the Federal Fair Housing Act really provides protections for residents that would be involved in this dementia center and allows them to live in a residential zone of their choice. So it's not appropriate for this specific development. It's not a quiet and serene environment that would meet the needs of Alzheimer's. Please let me finish.
You're giving a very compound answer.
Please let me finish.
It's answering.
You asked me if there's a zone where it's permitted.
He's answering questions that I didn't ask, though.
Yeah. No, you did. I am answering the questions you asked.
Okay.
Okay. Yes.
I don't mind the answer, but okay, go ahead.
And
Mr. Higgins.
Yes.
I'm sorry. Yeah. Let him finish his answer. If you object to, he goes beyond, you can put your objection on when he's done.
Okay. And so this development would not be permitted in any zone in the township?
Not even the Route 35 overlay?
No, not this development.
Why not exactly?
Because that lot is too small, and quite frankly, it's not residential in character, and one of the very important aspects of this application is that it be in a zone where there's residential in character.
And this was modeled after the Hodgewick development, is that the name of it, in Netherlands? Hodgewick?
I don't remember the exact name of it, but I know it's modeled after a development in Netherlands.
What kind of zone is that
I have no idea,
located in?
and I don't know anything about the zoning in Netherlands.
Would you be surprised if you learned that it was in a very densely developed zone?
No.
You wouldn't be surprised?
No, I wouldn't be.
Okay.
Netherlands is more good.
The location along the parkway, does that, you talked about how the parkway made this location accessible. Is that correct?
It's got very good access, yes.
And would that be especially accessible to people from outside this community? And
it's a completely irrelevant question, quite frankly, from a planning and zoning standpoint. It would be accessible to people from outside the area,
Sure.
But quite frankly, and I have to give you a complete answer, is that this type of facility, people don't put their relatives 50 miles away so that they can go visit them once a month. They put them close by, so it would be for people from within the vicinity of the site for the vast majority of the occupants.
How frequently would you be expecting visitors?
I don't know.
Were you able to get Exhibit A1? Can I have that, please?
Cindy testimony.
I don't have, I can fill out an Oprah request. No, I don't need to keep it right now. Yeah, I'm just going to ask questions. Mr. Higgins, I'm referring to Exhibit A1, which is the Certificate of Need.
Okay.
And you testified a little bit about the Certificate of Need during direct. And you talked about how this stands for the proposition that there's a need for this type of facility in the region or area. Is that correct? How do you define region or area?
I did not define region or area. That's defined by the state, and I don't know exactly what they outlined as the region or area.
Do you know if the region or area is specific to Holmdel, or would it be greater?
It would be greater than Holmdel. And that's an assumption, but I think it's a fairly accurate assumption.
And how much weight do you think that the board ought to give this Certificate of Need?
I think they should give it considerable weight.
Do you think this is a per se indication to this board that that there's a need for this kind of facility?
We had last year.
Yes. That's why it's called a Certificate of Need.
The certificate itself, it's a project narrative.
And the fact that it was expedited, I think adds to that.
Yeah, this is it.
Could you talk again about what you meant by expedited? How did that work exactly?
An expedited application for a Certificate of Need, the criteria is that at that application, the granting of that Certificate of Need will not have an adverse impact on other facilities within the region, which means it wouldn't compete with them and take business away from them and adversely impact them.
Doesn't that almost mean that there isn't an intense demand if it's not going to take business away?
No, it means just the opposite. It means that the demand is in excess of what's being met at the time. There's an excess demand, therefore that demand can be met without drawing from the other facilities in the vicinity, within the region.
Would you read the last paragraph of page 3, if you have it there in front of you? This is from the Certificate of Need.
Page, I don't know if we have the same page 3. Oh, wait a second. Is that?
Does that have any consideration for the new ones that got built in Holmdel and will be built?
This approval is not intended to preempt in any way the authority of any municipality to regulate land use within its borders and shall not be used by the applicant to represent that the department has made any findings or determinations relative to the use of any specific piece of property.
Isn't that exactly what you're doing?
What? No, we're requesting a use variance for a property within the region. That's saying that there's a certificate, if there's a need within the region. It's not saying that is specific to this piece of property. It's specific to the region, and this property is within the region.
And this certificate does not preempt the board's authority to make determinations as to the use variance, correct?
It does not preempt the municipality's authority, but it does provide substantial evidence in terms of demonstrating that there is a need, and that obviously the applicant has to demonstrate that the site can accommodate the use, which I think the applicant has.
I just want to jump in real quick. This document that I looked at was dated last May. So I wonder if that considered the 2 new developments or senior buildings that have been built since that.
They would have also been subject to certificates of need, and that would have been considered because the state would have had that information available to them.
Okay, so a new one is on 35.
The new one is on
And
35.
then the other one's in the
correct.
Commons, 200 Commons Way.
Yes.
Those two are in this document already?
I don't know if they're in this document, but they would have been considered. I can't conceive that they wouldn't have been considered.
So we don't know for sure if they
Well,
was.
the Commons one has been around, on the paper for 15 years.
Yeah.
Brightview was approved well after the
It was
date of the
approved only a
certificate.
few months ago.
Right.
Fine, as we have discussed in prior hearings, there are very few units, if you will, that related to dementia. It's a much bigger facility, has a lot of assisted living, which is different from dementia.
Okay.
We should probably, for next time, I'll have that resolution, so we have some more detail about Brightview, and we could admit it, since we're talking about it. But I think we'll find that there were more beds dedicated to dementia care in that project.
I think we already know the answer. Later, it's the planning board attorney as well, so.
And Kate, there was like 180 total?
Yeah, we already just, I don't remember the number offhand, but we did put this number on the record at some point.
And about half were for dementia. Not even half, a lot less. Yeah. But it's a different site. Again, it's a different site. That was permitted over there.
It was a conditional use in that zone.
Right, but I'm just saying, in that letter, I wonder if they considered these other two complexes that are now here in Holmdel.
No one has that answer here.
Yeah, I know,
But-
nobody
but
does.
These things do get submitted.
So should that,
Usually substantially before these hearings.
but should that be updated to comply to
I
what
think
we
these are
have
good.
today?
They're good for a period of time, if I'm not mistaken, and
Yes, they are.
They do not get updated.
Well, I guess Lisa's point is whether there's still the same need as there was when the certificate was issued.
Exactly.
Based on the other beds that were from the.
And how much weight I want
I can
to hold
attest
to that?
As a matter of state law and reliance on the CON standards, this document can be relied upon by the applicant, and when new applications come in, and apparently would have been after that, they consider certificates of need. Again, the needs would have been different for that, based on what just Mr. Flieger said. So what Mr. Asadi is referring to is the right of the board to consider the specific site. But my position is, and I think it's backed up by regulations and the statute, is this certificate of need can be relied upon definitively in terms of the need, which also is amplified by Ken's testimony earlier this evening. And I suggest that's what Mr. Higgins is referring to too. So we're not saying we don't need the use variance. We're saying that the need is very apparent, and it's defined, at least in part, by the fact that a certificate of need was issued, which can be relied upon by this applicant.
And it does have an expiration date of 2026, if I'm not mistaken, on the document, so.
Thank you.
Yeah,
Right.
it's a good question.
But
However, this document does not expire until 2026.
I got it, but, he made a statement that we should heavily rely on that document, and I'm not sure I agree with that.
That's fine. You're
That I-
entitled to
that- yeah.
give
How
it
much weight?
less.
Right, I don't know if I would give it the weight that he's stressing because of the facts that I happen to know
All I
about.
will say is it's a valid certificate
Okay.
of need until 2026.
And it's good till 26.
Does not need to be amended based on anybody else's application.
Okay.
Thank you. And that's why I said in part, it describes the criteria, and it defines and concludes that there is a need in the region.
And the certificate of need is required by state regulation for a facility like this, is that
Yes.
correct? And is that for land use purposes, or is it to satisfy other regulatory schemes that don't really have to do with land use in particular?
It's for the purpose of determining that there is a need for that type of facility within the region.
Under a certain set of regulations?
Yes.
That are non-land use regulations?
That's correct.
Okay. And you talked about in your direct that you were laying out the case for a D1 use variance because you mentioned that the amenities that are included with this are not permitted uses. Is that right?
That's one of the reasons, yes.
What kind of amenities were you referring to?
I was referring to the fact that you have the store, you have the clinic, you have administrative facilities on the site, you have a gym, you have an exercise room, which is the gym, those types of amenities. In addition to the walkways that go out throughout the site connecting the buildings.
I was a bit struck when we got into that conversation, or you got into that conversation with the board and its professionals about likening this to 7 community residences, and it was pretty coincidental that 7 times 15 is 105, and I get that
It was coincidental.
But a nice coincidence for you. But I mean that. What's the word? Serendipity? But these buildings are all connected, correct?
That's correct.
Okay, so they're not even if we were to.
They're not all corrected. There are 7 separate buildings. One of the building has 3 dwellings in it that are connected. 2 of the buildings have 4 dwellings each that are connected, and then there's the 2-story building that has 2 dwellings upstairs and 2 downstairs.
And it struck me as an objector's representative here that when you testified about the 7 community residences and how that would fit mathematically, you likened it to residential use.
Mm-hmm. Yes.
And you thought that was appropriate to think about it that way. Why is that?
Why? Well, first of all, it is a residential use. Okay. You have 15 separate dwelling units that function as separate residences. And the difference that I was trying to point out is the amenities, and then the configuration of the site itself also is different than what would be permitted. So those aspects go into the D1 variance.
And when it was inconvenient to stay consistent with residential use when it came to impervious coverage, you looked at it through a different lens, and you looked at it as some of the non-residential uses.
Well, first of all, because the fact that it's not a single-family residential use. It's a residential use. You have buildings that are have 3 dwelling units or 4 dwelling units that are connected, and it's a configuration and a use that's not considered by the ordinance in terms of its configuration and in terms of the amenities. But when you look at the Blake Gardens case, which really talks about the fact that this type of facility should be considered a residential use, I think the decision in the Blake Gardens case, while that was a separate standalone building, I think the concepts are the same, and one can be related to the other.
And how many, and I'm appreciative of learning about the Blake Gardens case this evening, but.
It was a Freehold Township case, by the way.
I lived there too. I think I was on the zoning board at that time.
Yeah, I knew you were on the zoning board, yes.
I might have been coaching soccer that night, right? I don't think so. I think I was coaching that night.
Yeah.
Was that for a 15
yes.
Person residence?
Yes, it was.
Okay.
And it was actually a case that attacked a state ruling, a state law, and that it actually invalidated a state law.
And that's the facts in that case then are
the facts
substantially
they're different. I think
here.
that the result and the findings can be related to the other.
In some respects, maybe
Yes.
I agree with you.
Yes.
Okay, I don't have any other questions. Thank you.
Okay, thank you.
I think the case bypassed zoning and went back to a lawsuit and they told, so.
That's a better reason.
I agree.
Yeah,
Yeah, it never went before a court.
I read the case while we were.
That's correct. They filed an application for
Once the
structure.
permit was denied, they told them they could appeal to the zoning board, they would grant my.
Yes.
That's right. It's only a 70A appeal.
Yeah.
All right, let's keep going.
Good evening, Brian Clancy from Dasty & Associates on behalf of Middletown Township. Mr. Higgins, you reviewed the master plan re-examination for Holmdel from 3/17/2020 in preparation for your testimony, correct?
Yes, I did.
And did you review the land use goals and objectives?
Yes, I did.
And do you remember what it said about adhering to zoning schemes?
No, I don't.
I have listed in here is encourage the township to adhere to zoning standards and only grant relief where standards are met in accordance with the MLUL, Municipal Land Use Law.
And that's what this application is about.
Okay.
The applicant is seeking relief from the zoning standards according to MLUL.
Right. And did it also speak at all in any language about assisted living or expanding assisted living?
Yes, it did.
And what was the recommendation?
I will have to look, I have it here. And I'm trying to figure out what page it is.
Oh, I'm sorry, I'll help you. It's on 32. It's actually right where we were looking before.
What? No, I mean, I'm looking at my outline. I have it written here in my outline. I'm just trying to find it in here.
I'll be happy to read it to you. It says,
Okay, sure.
recommend that assisted living / congregate care facilities be included as a conditional use in the Route 35 overlay zone and it lists some bulk standards.
Yes.
Okay.
Okay.
And to be clear, this is not within the Route 35
That's
overlay
correct.
zone,
That's correct.
correct?
It's not. That's why we're here.
Did you review, across the street to the south and to the west is Middletown?
That's correct.
Did you review any of the zoning requirements over there?
Yes, I did.
And what did you find?
It's the zoning across the street is residential. And I didn't go in the specific, there might be other uses that are permitted in those zones, but I didn't go look at the other permitted uses. I think it might have been R40 also, but I don't recall the specific residential zone.
So we have R45 zone
R45,
there.
okay.
And I did look at them. I do not see anything. I do not see an assisted living facility as one of the permitted uses in there. Would you want to take a look at their zoning, or are we?
Considering the fact that you have Red Hill Road, which is a 4-lane road, you have the exit 114, interchange 114 from the Parkway, I don't think, and the amount of buffering that's being proposed along Red Hill Road with this application, I don't think there's any impact whatsoever from this site on anything that would be developed in Middletown. And quite frankly, I will say the same thing with regard to that residential property in Middletown. Any of that property could be developed. If it was developed and subdivided as a single-family residence, any of those lots could be developed for group homes at 15, for 15 persons per lot.
But again, that's not what we're talking about putting in this particular application, correct?
No, we're talking about putting in something in terms of intensity is very similar.
But we're talking about putting in a 105-bed facility, based upon the application, not upon this 7-building, project that's been kind of brought up tonight.
We're talking, 105 beds, and again, what would be permitted by ordinance in Holmdel would be 105 beds on 7 separate lots.
Okay.
So it's similar. It's not the same, but it's similar.
Okay. Regarding some of the additional facilities that are involved here, with a cafe, grocery store, gym, theater, restaurant, walkways connecting buildings, the 7-building construction project would not include any of those facilities, correct?
That's correct.
Okay. And I don't think it was clarified on the record. The current zoning, it is not currently zoned for commercial use, correct?
Well, the site is used commercially as a pre-existing non-conforming use.
All right, so the question is the site currently zoned for commercial use?
It's not zoned for commercial use, but it's permitted to be utilized commercially. If the use were to be expanded, it would require a D2 variance.
Okay. And then just regarding some of the site photos,
Garden center is commercial.
it's been characterized kind of repeatedly tonight as not attractive or with poor aesthetics, correct?
Yeah, I was being polite, yes.
Okay. Are those photos, though, indicative of its current farm use?
But There really is no current farm use. There are some animals on the site that occupy the site, and again, the testimony from Mr. Potter was that this is not a farm, that's a hobby.
Okay, so the
Can I
photos that
interrupt you a second? I'm going to just jump in here. That property is taxed as farmland. So whether you call animals not farming, it is on our roll
Okay.
as a farm area, and it's taxed that way. So to
Okay.
me, that's a farm.
Okay.
There are two uses on the site from a tax point of view. There's part of it is commercial, and it's taxed commercial, and then the open area the animals are is what's assessed as farmland.
Yes.
Correct.
So-
As previously testified,
Yeah.
3 acres is used commercially, as we said.
Yes.
15.55 is under farmland tax assessment, and that's why we've got the different.
I know.
Yeah.
But
And generally-
we don't say that. We should
Yeah,
say that.
okay. Just to clarify, so you understand, when I think of a farm, I think of something that is being farmed for profit. And this is really a hobby. Yes, it's a farm, but it's a hobby.
In order to qualify as a tax for farm, you have to
That's
justify
right. Yeah,
income of a
that's
certain
correct.
amount.
You're right.
You can have
I stand
beehives
corrected.
on your land,
Yeah.
and that would qualify
I stand-
for farming.
I stand corrected,
So-
yes. Yes.
But, Jim,
Mhm.
why did you talk about intensity in terms of farming in relationship to the proposed use and the other uses that are not residential?
What?
In other words, what kind of farm could you have there that you?
Oh, you could have much more intensive farm use there on that site.
And why did you emphasize that?
But because it's something that is entirely possible on the site.
And why is that relevant
Yeah.
to the criteria under SECA and the negative criteria?
It's relative to show what the intensity of the use of the site could be under the current zoning.
And you took those photos that you put up, correct?
Yes.
And that was photos of an active farm, correct?
That was photos of a site that is utilized commercially for 3 acres, and to stand corrected, partially, the balance of the site, 15 acres, is utilized as a farm.
Okay. And under the negative criteria, you mentioned some things about heights, and you talked about barns and silos and how they could be tall. Barns and silos are typical of farmlands, correct?
They can be constructed on farming sites.
But my question is, those are the types of buildings that are typical if you were looking at a farm, correct?
No, depends upon the type of farm. The exhibit I showed of the Disbrow Farm in Monroe Township, that is a farm. There are no barns, there are greenhouses, there's a field with plastic over it. I have a client in Holmdel Township that has a 79-acre farm. There are no barns on the farm. It's got greenhouses.
Okay, so it's your testimony that barns and silos are not typical on a farm?
It's my testimony that barns and silos would be permitted on this site as of right with the zoning without site plan.
I don't think I'm going to get an answer to the question.
Well, that was my testimony.
I'll move on.
Okay.
And regarding sounds under the negative criteria, you mentioned animals and tractors and farming equipment. Is that sounds that are typical of a farm?
Yes, it is.
Okay. And if a farm use is permitted, which it is in this case, wouldn't residents and visitors expect to see farm sites and hear farm noises?
I don't know what they would expect, to be quite frank.
Okay. If you remove the farm sites and the farm noises, won't residents notice noise a little more than they would if the farm was there?
Not that I'm aware of.
Okay. I think that's it.
Okay.
Just to finish up, again, the council was talking about the farm, maybe the question, but you were talking about potential use of the farms, could be pigs or chickens or lots of different.
Yeah, to protect the potential agricultural uses of the property.
Yeah, but why do all these uses have to sound so negative? You're making it
They
sound...
don't-
I mean,
no,
why
I'm
can't
not-
we have a farmer that had nothing but beehives there, where I wouldn't even hear them? If
You
that's
could.
a farm.
You could, absolutely, but what I am trying to show is that what this application is proposing is far less intrusive and far less, has far less negative impact on surrounding properties than what could be constructed on the site as permitted by the zoning.
I understand
So what
that,
I'm
but-
showing you is that the most intensive type uses that could be constructed on this site.
I just don't like the way this is going when you're always giving us the negative. So it's making it sound like we don't have a choice, that if we said no to this, that we could possibly have something like that on there. And I don't like that way that you're presenting it.
Well,
to us.
I'm giving you the legal testimony.
Yes, it is.
Well, then give us some other good possibilities, not just all the possible worst things.
Jim,
Well, then,
why do you
I need
couch,
you to do that.
why do you couch your testimony in the way you have in terms of what could be used in relationship to what might be used? Why is that relevant? Why do you have to
Because the way the law reads is that you have to show that what you are proposing is not as detrimental to the surrounding property as what could be, not necessarily what will be, but what could be permitted on the site. So what I'm talking to you about is uses that could be permitted on the site by right, by the zoning, and in many instances without site plan approval of any board, and how those uses could be much more detrimental than what the applicant is proposing. It goes towards negative criteria. I'm not saying that those uses are necessarily going to happen, but what I'm saying is that they could happen.
And the law is you have to analyze what could happen. Is that right?
That's correct.
That's what the SECA standards indicate?
Yes,
correct?
that's correct.
And again, you were involved with that, and you're familiar with all the other case law since then, dealing with D1, SECA kind of inherently beneficial standards?
Yes.
And is that what the courts have always ruled?
Yes.
Could be rather than what might be?
Yes.
Just one observation, that there have been issues elsewhere in Holmdel about that kind of thing, in that there have been developments on farmland on Route 34, which have been, township's been in and out of the courts with some of those developments, which are all done under right to farm, and they are farmland uses on farmland with no site plan. So those are things that could occur on this property where something else not to occur.
Yes. And that's the point. I wasn't trying to use scare tactics. I'm trying to make
Yeah.
a legal argument.
Is that also relevant to the statutes on right to farm?
Yes. It's my understanding it is. Yes.
Yeah, because the right to farm is what permits all of those other, once it's a farm, all these other kinds of things are considered ancillary to the farm.
Yes.
Okay. All right. Any other members of the public have any questions of tonight's testimony? Boy, it's gotten quiet. And it's 4 minutes of 10. I think try to wrap up for this evening. At a minimum, what we'll announce is that we will continue this public hearing on July the 20th. It's 7 o'clock with no further notice to the public. There may be one other short item on the agenda prior to this. I think there's also a completeness waiver one. What? 2 other items?
Yeah.
What, completeness waivers?
But is the applicant finished with all his witnesses
Yeah,
and his stuff?
I'm just going to get to that, as to where we're at now. Jill, you had a question that hadn't been addressed yet. You want to let Sandy know what the topic is so they can address it?
In terms of the facility, I know it had been farmed, and you mentioned there would be more gardens, and I'm just curious to know the level of pesticides that have been used, that might be used, because, when we look at dementia, we see the rise of it, we have to question some of the environmental aspects that perhaps cause some of these conditions. So I am curious to know if that's been factored into anything.
Well, I have to pull it from Jim and Hal. I would respectfully submit that goes really back to some of the testimony that was initially from Larry Carlson and especially Cindy Jakes. And I don't believe there was a specific question on pesticides, But you did hear about the quality of care. You heard about how there's an integration with modern comprehensive research facilities that Cindy mentioned, leading
I think,
universities.
Sandy, I think the question is more, what's the current condition of the property?
Right, and if you're adding more landscaping, right, so you're changing the basins, right, so there's more landscaping now.
To what extent is there arsenic in the
Sure.
soils and all of that kind of thing?
Thank you for clarifying that. Great question. So this goes back to testimony by our project environmental specialist who was with us in 2021, and we didn't repeat that, but go figure. But there was a comprehensive report that's part of the record, and I would synopsize that the testimony was that any substance that is, which include pesticides, arsenic, anything like that, will be ridden of, and that is actually one of the advantages of granting this, because otherwise there are these carcinogenic, well, not carcinogenic, but substances that don't comply with clean dirt. So that will all be cleaned up, and the description was how we are under strict standards of the state, and in order to get a clean bill of health, if you will, the person who's testified, who's actually an agent of the state, he has to be assured that it is clean, there are no pesticides.
So that report is on file, the environmental report. Loretta can get you a copy of it if you can't find it.
Yeah, I'm just noticing, you know, even recently, the Supreme Court is looking at the Bayer Monsanto case, and they don't want to touch it, right? So they're looking at glyphosate, and they're questioning the role that it may have, you know, in our future, because there is concerns about what's being used on a regular basis, and should it be used? And, you know, we're talking about people who have a health condition, and we want to make sure that it's not going to impair their condition anymore.
I couldn't agree with you more, and again, I just looked it up, it's A4, and the Babcock report deals with that, and it was on October 20th, 2021, and I would hope that you would agree that this not-for-profit statewide organization is very much interested in doing the best to care for dementia residents. So to have any kind of potential situation on there that would be negative to that approach and that goal would not be permitted. And that part of that puzzle is to have a clean property, to get rid of all of what exists there at the present time, from agricultural use and the commercial uses that have been testified to. Thank you.
Okay. Well, let's just, Marty, you want to summarize what we need, what else? Do you have any further witnesses?
No, not on direct.
Okay.
And
so
hopefully not on
You have the
rebuttal.
right for a summary yet? And
yes.
Our objectors may have witnesses yet and testimony yet, and that's yet to come.
Kevin, you still have two witnesses, is that?
Yeah, that's right.
And that's about, do you have any idea how long, or is that?
Probably within one meeting, we'll bang it out.
And that's a planner, and who's the other?
An administrator in the field of dementia care.
Okay, and do you have any other witnesses that?
We won't be presenting any witnesses now.
Okay, but you certainly have the right to comment yet.
Thank you.
And that will yet come.
And then we have
public comment.
Public comment, and
it may be a suggestion to the attorneys and the board members that maybe be prepared to maybe have a summary of where we are before the meeting, if you want, if the board agrees to submit a written summary of your, because there's so much, you know, there's numerous meetings. I'm not talking about a 20-page, you know, report, but if it may be helpful for all the attorneys if they agree to submit, you know, a small position in writing of where they're going. You know, we can probably assume at the next meeting there may be a point where we get to a vote. So I would say if we all agree that we want that and you guys are willing to do it, I suggest that maybe we.
yeah, but certainly if you and Sandy at least provide a summary of issues that you're concerned about, and so we'll have that for next time.
I appreciate that, and what I would offer is that any time you would like from now until the next year, I am happy to provide a 6-page summary of what you've heard to date, and to the extent that anybody might want to look at it, I have an appendix which goes through every bit of testimony from September to, well, we'll go through today. If anybody wants to verify, for example, what certain people testified to, including, for example, the environmental scientists, you can look to see, if you want to look at the transcript, you can take a look at it. So I would offer both of those components, and if you'd like to indicate a point in time that you'd want the 3 attorneys to provide that in writing, so that there'd be enough time.
So if we had to say a week or 10 days, prior to the July 20th meeting, so that it can get distributed and people have a chance to read it.
The board should decide if they want that first, and then I want to know if you would be willing to do it, but.
Yeah, more than willing to do it.
I think a summary would be helpful.
I just want to say, we haven't even put on our witnesses
I
yet.
understand.
So it's very difficult for me to provide a summary when I haven't.
Well, okay, but if
You know what
Mr.
your witnesses are going to say.
I don't know, but
Okay. Kate and Bob, do you have any questions or comments, or?
And that's not meant to prejudice any comment. You can always make your oral summations. I just thought it might help board members if there's something in writing to focus on, if they agree. Again, that's a board decision, not a.
Would the board members welcome something like that, summaries? I think it'd be helpful.
Yeah, that's really what it comes down to. Are we going to read that thing?
I would read it.
Yeah. Okay, yeah. The answer is yes. And Kate,
If you do provide it, I'd ask that obviously provide it to council.
Of course, yes.
And obviously.
everything goes to Loretta, and Loretta can make it available.
And again, if someone fears the length, it'll be 6 pages. If you want to look at the appendix, you can.
Fine.
But that's just backup.
Kate, do you have any final comments for tonight?
No, nothing more from me, Mr. Chairman.
Bob?
Nor do I. Thank you, Mr. Chairman.
Okay, in that case, we're adjourning this hearing for tonight, and to continue without further notice till July 20th. And let's see, Kate or Bob, do you have any further reports for the board for this evening?
No, I don't.
No reports tonight, Mr.
Marty?
Chairman.
Nothing? Okay, in that case, any board member have any other item? Sandy, you have something?
No, again, we have completed our main case, so I'm not going to bring any witnesses next time. I'll be here, ready to listen.
Okay, good.
Just, Sandy.
Yes.
I mean, obviously, if there's a need to redirect your own witnesses, that's up to you, but if you don't have them here, you're not going to be able to do that, so.
I appreciate that, yes, that's good.
If we get to a vote, so I'm not sure where we.
I appreciate that, so maybe I will have them in case they're,
At
yeah.
least maybe Mr. Higgins available, or?
He is available.
Yeah.
So is,
That's your decision.
Okay, if there's no further business for this evening, is there a motion to adjourn?
I'll make a motion to adjourn.
Is there a second? Second. All in favor? Aye. Opposed? No one opposed. We are adjourned.